approve ना हाउ टू अरे देखा जाऊनी ना थाऊ कौन मुझे देखियो ना देखा ना यूट्यूब काम कौन राजेश हाँ सबसे कौन था कौन
Very good morning to everyone. So it's the time for this session. As you all know that we are having a very prestigious people from our fraternity among us. So they are none other than Mr. Prasanna Behera and Mr. Rajat Panda. So they are already here. Introducing them, Mr. Prasanna Behera. He was born in the year 1989. His Bachelor of Law is in the year 2007 from Madhusudan Law College, and his Master in Law in the year 2013 from Utkal University. Mr. Behera is an advocate in Supreme Court of India, and he is also awarded as Outstanding Advocate of Odisha. Presently, he is a central government advocate, and he is a legal advisor of Shri University, Madhusudan Law University, Utkal University, several educated institutions also, various companies and institutions also. Having academic interest, he is a faculty in various colleges. He is socially also he is very active person, and he is the president of Rotary Club of Cuttack and recipient of several literacy awards. My dear students, if I start talking about him, the day will go away, but my speech and he will never ever end, because I'm very much familiar with him. So please give him a big round of applause as we are having him. Now Mr. Rajat Panda, he is also a very brilliant personality in our fraternity. We can get so many, we can be inspired by him. Mr. Panda was born in the year 1992. His school, he has passed out his 10th in the year 2007 from Stuart School, and plus 2 from Stuart Science in the year 2009. His Bachelor in Law from University Law College in the year 2014, and his Master in Law in the year 2015 from National University of Juridical Science, Kolkata. He has backed as civil judge in the year 2016. Then he took BRS in this year itself, that is 2022, while he was a civil judge. Currently, he is in the field of practice before Honorable High Court of Odisha. So it is a very great news to share with you. Even I came to know right now recently. It is a very great news that yesterday itself he was awarded with a very good award, that is Shiksha Ratna, that is 70. Respected dignitaries, the dais is all yours, my students are all yours. The session is now on. Thank you everyone.
नहीं सेटा था डाइस में बेटर हो हैं ये तो एकत्र जाएगी ना ये रख दिया मौजूद ये बॉस की करवा दे क्या ऑर्डर अच्छा कौनटा এটা ছুয়াম তো করব হ্যাঁ এটা পিল্লাঙ্গু দরকার আছে হালকা আছে কিন্তু ପିଲାଙ୍କୁ ଦରକାର ଏବେ ଓହୋ ওটা କ'ଣ କରିବା ତାପରେ ଆଗ ଷ୍ଟାର୍ଟ କରିବା ବୋର୍ଡ଼ ନାହିଁ କ'ଣ କରିବା ବୋର୍ଡ଼ ନାହିଁ ନା ବୋର୍ଡ଼ ମିଳିବ ହଁ ଠିକ୍ ଅଛି ବିଫୋର୍ वी ଷ୍ଟାର୍ଟ ତାପରେ ଚାବିଟା ଦେଉନୁ ଏଇଟା ଜାଣିବ ଟିକେ ଅବେ ମୋ ମନଟା ସେଇଠି ଅଛି ଆସୁଛେ ବୋର୍ଡ଼ ନେଇକି ହଁ ତ ଆମେ ଷ୍ଟାର୍ଟ କରିବା ଦେଖିବା ତାପରେ ଛିଡ଼ା ହେଇକି ବସିକି ଭଲ ଲାଗେ माइक इज ऑन तो जहाँ भी कोई लाइव है अच्छा ओहो स्मूथ डू वी रिक्वायर दिस माइक्रोफोन टू स्पीक नॉट रिक्वायर्ड ना बट सो फार एज दिस लाइव सेशन इज कंसर्न वेदर द माइक्रोफोन इज रिक्वायर्ड नो देन ऑल्सो नॉट रिक्वायर्ड ना सो व्हाई टू यूज दिस But you might require, because your voice should come if you. Yes. Any volunteer would help us. For interaction. So, good morning. It's very difficult to attend sessions in Sundays, right? Because you would have sacrificed many plans, programs, movie, and many other. So, sleep. Sleep. But who sleeps till 11 o'clock? Okay. So, no, it is there with me.
I know.
Touch.
Okay. Fix your OCD.
88.
Fix your OCD କହିଦେଲା ନା
ଆସେସମେଣ୍ଟର କ'ଣ ଅଛି କି? ଲଗେଇଦେଲି।
ନାଇଁ ଏଇଟା 88 ଲଗେଇଥିଲା ଏଇଟା ଖାଲି ପଛରେ ପୁsh କରିଦେବି।
ओके नहीं ये सामने था ना सामने तेरे सुनता
बट कैमरा
अच्छा कैमरा से अच्छा मैं मुझे भूल जाऊँ सॉरी नहीं पछार कैमरा रे आसीबनी थाउ ठीक है
बड़ सीधे लिखला
हाँ Yes, so can we start? All right. So let us before we start, I take the liberty with permission of my brother.
No, please do.
That we will have certain basic rules. Okay, if you agree to those terms and condition, okay, then we will proceed. Otherwise, we have other things to do, right? So if this value added certificate program, whatever session, whatever time we will be here and you have to bear with us, and we will ensure that we will not bother you, then certain important conditions you have to follow. First, let us accept that no one is a student, no one is a teacher here. Clear? Agreed? Okay. In Sonali madam's class, you might be student, she might be teacher, she has always been a teacher. So let's have a big round of applause for her for inviting us and for such a nice, wonderful introduction. We started studying law together. So she has been a very caring and a very authoritative friend. Okay, I'm sure now that quality would have enhanced to a great extent, and she loves to exercise the authority. So she has this right place. Anyway, so second is it will be interactive. No one-way communication. Right? Okay. Third, in the first two questions when I was expecting an answer from you, we noticed that we are using sign language. Correct? Any one of us is differently able who cannot speak properly. Please. No? So everybody can speak? But yes, you're also not saying yes. Everybody can speak. But now everybody can speak? Yes. Okay. So we will not entertain sign language. There is a caveat. Okay, if suppose in the classroom you want to send some signal with sign language to somebody else other than us, we have no problem. You can do so. That's your personal space. But for us, when we are interacting, let us don't use sign language. Clear? Yes. Then also we are not. Next is, if you want to disturb, then No, disturb. Don't leave. If you want to disturb, you can. You are at your liberty, not a problem. You want to put question, you can put question. You want to interrupt, you can interrupt. So there is no restriction. Clear? Now sounds more comfortable? So that what will happen? The drafting, court proceeding, those words comes with a feeling of, boring, or feeling of being very, what do you say, monotonous, right? So you won't feel that. So you are at your liberty, feel comfortable. जिनके पास वो किताब, पेन, पेंसिल है, सब साइड में रख दो. अगर जरूरत होगा तो ठीक है, लिख लेना, बट जरूरी नहीं है. ठीक है. We go to watch movies of 3 hours. Any one of us take pen, pencil, notebook? No. तो एक 45 मिनट्स का सेशन होगा, उसमें क्यों, क्या जरूरत है? Correct? There is a technique, memory technique. We'll share that later on. So, okay. So we start with, I would ask few questions. That what do you expect from this session? Quick, don't waste our time. I mean, all of us time. What do you expect from this session? Then only we can continue. Otherwise, makes no sense. We can have khatti and go. Yes.
To get certain practical knowledge.
Certain practical knowledge. All right. Then माइक्रोफोन नहीं होगा तभी बोल दो, कोई प्रॉब्लम नहीं है. It's not working. ठीक है.
So I have a question for Rajat sir.
हाँ.
That what exactly prompted you to leave the job?
We'll come to the questions. अच्छा, we'll take questions first.
I will take that question. I will take all the questions.
हाँ. We take note of that question. Very good. Or if Rajat sir wants to answer right now, we can.
No. We can take the questions.
We will take questions. Huh? Yes. What do you expect? If there is no expectation, I would say that all of you are saints. मोक्ष के रास्ते पे हो सब. कोई expectations नहीं है.
Like he said clearly that he wants to know why did I quit the job.
बस.
So there must be
in the
certain
entire
questions.
session we were discussing. In the entire session, during the deliberation, I hope you will get the answer first.
Because for that reason only I have come here, because because I share the same platform with you.
Then very good. Then she is very clear. Let's have a big round of applause. What's your name? आराम से बैठ के बोलो ना, क्या problem? Then your answer will come at the end. Otherwise you leave. I don't want to leave you. Is that fine? We'll provide you all food, recreational. No, it's a problem. भूख लगेगा तो बैठोगे कैसे? अच्छा, yes, बोलो. Yes, last. Whosoever thinks that he or she is sitting in last. अरे खुद बोल दो, पीछे क्यों देख रहे हो? हाँ.
गायत्री कहो.
हाँ, yes.
So we are here, like I am here to know something extra and some tactics to be successful in
Okay.
this field.
Which
I
field?
don't know yet.
Which field?
In law field.
Okay, law. Okay. One, yes.
About legal research.
Legal research.
We have much, so if you could say something on the legal research.
Yes, we will talk about legal research. Yes, we will.
I have heard a lot about you, so I really want to know how is your journey.
I'm scared now. when you raise that a lot about, then I'm scared. सबू मिच्छा कहता है किच्छि.
Good thing.
हाँ.
Now you can't say मिच्छा कथा.
से भी मिच्छा कहता है.
I'm here to listen about your experiences.
अच्छा, okay, we'll share that also. All right. So basically we are here to discuss something which are not taught in the syllabus. Number one. Number two, which will make you different. Correct? So I will start before going to the core topic drafting. I will start with a concept which I always say, that is called setting the radar. ठीक है? setting the radar. I said you may disturb. That doesn't mean you may disturb inside the classroom, inside the room. Okay, don't go outside and disturb. Anyway, so setting the radar means let us understand this entire legal profession or field, as you said, Gayatri, okay, is like an ocean, and we all are like a ship in the ocean, right? And each ship wants to reach at a particular destination. That destination is known as shore or a port, okay? And you want to reach at a particular destination, not like कहीं पे भी जाके पहुंच जाते हैं, okay? Not like that. So if you want to reach a particular destination, you want a direction, correct? And you want to communicate with that direction to that place, to know that whether that place is good for me or not, whether that place is appropriate for me or not. Is that clear? Agreed? Yes. Very good. So let us pause here. Now what destination you all are expecting for, or you want to reach? Just one or two quick. Yes. बताओ कहाँ पहुँचना चाहते हो? If this field is an ocean, you are a ship. Where you want to reach?
Asutosh, answer.
Wait. Let me do it.
You wanted to answer.
Wait. Students can disturb, teachers cannot. Yes, Asutosh. Who is Asutosh? Yes. You want to become a judicial officer. Very good. Next. बैठ के बोलो, कोई प्रॉब्लम नहीं.
Sir, a big corporate law firm.
Big corporate law firm. Wonderful. Next. One more.
So, a practicing lawyer.
You want to become a practicing lawyer.
Only practicing lawyer.
Excellent. Wonderful. So you want to be a good corporate lawyer or a part of a law firm. Somebody wants to become a judicial officer. Somebody wants to become a practitioner, an advocate, right? So these are all your destinations, all the ports or the places where you want to land. Okay, but you need to communicate that whether that place is good for me, whether other than that place, what other options I have. Like a ship communicates with this port. How a ship communicates with the port?
It gets anchored.
The anchor doesn't help in communication.
Someone who's there already.
How you communicate?
Someone who's there already.
Correct. How? I said that is who you are communicating to. Now question is how? Signals. Very good. How do you send the signals? Radar. Correct? So that means you need to have a radar to send a signal to who is there, somebody there to help you or communicate. So what is your radar? If you are a ship, what is your radar? Okay. The radar is what extra activities you are doing or what are you doing to set the radar. I would say this program or other activities, let's say you're participating in symposium, you're writing articles, you're writing books, you're participating in moot court competitions, you're participating in any other curricular activities not within the syllabus. These are your radars. Those radars will help you in communicating various ports or various destinations to make you understand that whether that place is good for you or not, whether that place is comfortable for you or not. In simple word, whether that profession, that place is a cup of tea for you or not. Is that clear? Yes. You have an experience of those places, right? That's why you do internship. That's why you do various certificate courses. Somebody wants to become, let's say, you want to become a part of a law firm, corporate law firm. So you need to, if you write articles on corporate laws, let's say recently, we have IBC, Insolvency and Bankruptcy Code, functioning of NCLT, right? So you write articles, it is being published. Then law firms will see that, what's your name? Sumit. Somebody named Sumit from Utkal University is very good in writing such and such. Next time when you apply for your CV, this radar which you have fixed have already sent appropriate messages, signals. They will welcome you. Right? Or otherwise, they might give you an invitation. I have seen my friends, my seniors, by way of doing internship continuously in 1 or 2 firms, before their 5 years course, they have got invitation, offer letter, come and join. I'm not lying, there are people, right? Because they have set their radar in a very strong and effective manner. So what we need to think and work on is the stronger and effective the radar we fix, and we do something which makes us different from others, is the effective tool to reach at your destination. First point is clear. Now third, and first was the rules, second is this. Now third, whatever we do in the entire legal profession, ultimately we are social engineers. We interact with the individuals, human beings. That's why we need to develop certain skills. Correct? Suppose, let's say, I'll give an example of doctor. What a doctor ultimately does? Treatment. Right? So, before treatment, what he does? Diagnosis. Right? So, we'll directly come to the core topic of drafting. If treatment is followed by diagnosis, whatever activities you are doing or you would do in your legal profession, drafting is like a diagnosis. Okay, suppose you are a lawyer. No need to say that whether you need to learn a drafting or not. You are a corporate lawyer, or you are a partner in a big corporate firm, Sumit and Co. Right? Of course. And suppose somebody says that I want to become a judicial officer, then also you need to know drafting. Right? Anybody, like for example, I'll give an example. So, what's your name? Pragyans. You stay in Bhubaneswar. Which area? Govt. So, just your neighbor in the morning comes to you, ki Pragyan, yesterday night you are studying law. Let's say you are in first year. Yesterday night you were sleeping. Some persons came and the entire house has been, robbed. Okay, and all my articles have been taken by somebody. There is a robbery. What to do? He calls his friend or senior. Sir, what's your name? I'm asking, sir. Abhishek ji. He calls Abhishek. Abhishek ji is an excellent lawyer in Delhi, practicing in Supreme Court. He calls ki, sir, my neighbor has this problem. Then Abhishek ji says, what Abhishek ji will say? What he will advise? He will file an FIR. Okay. So Abhishek ji says that Pragyans, you advise your neighbor to file an FIR. Now Pragyan says, just imagine, Pragyan says, I asked my senior or a friend or a brother who practice in Delhi to file an FIR. Please book a ticket. Let's go to Delhi and file an FIR. Correct? Is he correct in his suggestion? No. Okay. Now Abhishek ji says that you file an FIR immediately on an emergency basis, on a very emergency situation, you file immediately. Now where he will go? Correct? So what he will do? So first point is you have to apply his logic. Even if he is not he is not aware about the procedure. So you have to apply his logic where to go. So there question comes, why he will go to the nearest police station, not to Delhi? Jurisdiction. Okay. Now while he goes to the police station, he has nothing. What he will carry? Paper, pen or police. You can go and write there also. So you have to write and give it. So there you need to learn drafting. Right. So drafting is always backed by a little bit of logic and a common sense. Only learning drafting will not help you. I can draft wonderful petition with big words, excellent words, but the problem is I don't have logic. Then, so while we'll discuss about drafting, please open the logic quotient of yours. Clear? So let's come to any volunteer who can help us here. Just answer. Hello. आइए. हाँ आपको कोटी चाहिए. हाँ टिके था तो पटो जियो टिके था. बॉस था ने भीतर ऐसे. Yes. हाँ पेन. अच्छी. अच्छा. All yours. जो कलर पसंद है लिखो. कहीं. और छाड़ी बनी. अच्छा अच्छा. Okay, okay. So, what we'll write is drafting. Acha, anybody who has studied in your syllabus drafting? In your syllabus that would have been, what was this subject?
Drafting, pleading.
Okay, let's pause here. Drafting, pleading and convincing. Okay. So how all of us have read it? Wait. No. We have read it how? How? कैसे पढ़ें?
Teacher used to teach theoretically only. Simply.
Let us not talk about the teacher. Teachers are boring, including us. So we say we are not teachers now. We are like friends. Okay. So how we have studied? That is please open your logic quotient. How? Verbal. That means what is drafting? Then what is pleading? Then what is convincing? Then अरे आपने क्या पढ़ा बताओगे तभी जाके आगे बढ़ेंगे. हम तो पढ़े ही नहीं है. हम सीखे हैं जो सीखे हैं प्रोफेशन में. हाँ.
The format of drafting something.
Okay, the formats.
Plain written statement.
Okay, we'll twist it. We will read only drafting, no pleading, convincing. Is that fine?
Yes.
Huh? We'll only read for drafting. We'll not discuss about pleadings. We'll not discuss about convincing. Fine? Yes, अगर सब बोल रहे हो तो anybody who says no, there is the problem. There is the problem. You cannot read drafting alone. You write drafting.
Okay. Yeah, this question came when somebody actually said कि हमर कौन पढ़ा होची से कहले कि ड्राफ्टिंग प्लीडिंग कन्विंसिंग पढ़ा होची. छोड़ भाई पचाले जे केते पर्यंत पढ़ा हैला से कहले ड्राफ्टिंग टा पढ़ा हैची प्लीडिंग और कन्विंसिंग बाकी.
Are you getting my point?
Question is कि ड्राफ्टिंग ऑफ व्हाट? ड्राफ्टिंग ऑफ प्लीडिंग एंड ड्राफ्टिंग ऑफ कन्विंसिंग. So it is not drafting गोटे अलगा जिंस, प्लीडिंग गोटे अलगा जिंस और कन्विंसिंग गोटे अलगा जिंस. So we can't read drafting without not reading pleading and convincing.
Am I clear? Are you getting this point? So drafting, then do it. Huh? Yes. Drafting of pleading. Off न लिखले चलियो. हाँ, off टा बुझी जावा. Logical, are you getting it? The very moment you feel that session is going to be bored or you are getting bored, please be very honest. Okay, sir, please stop here. Not a problem. We have got many other things to discuss also. Every individual has got some experience. You can share your experience, you can share ideas, we can be there. Role reversal होता है, ठीक है? Yes. Then drafting of convincing. Now let us read only pleading. But again, pleading has got two parts. Pleadings of civil pleading and criminal pleading. Format not a problem. We'll do it empty altogether. Clear? Is that clear? So now what is a pleading? What is pleading?
The aggrieved party, when it goes to the court to put his issue, he pleads before the court that to get justice regarding his.
Okay, very good, wonderful. Sir, what's your name?
So Sandeep.
Sandeep. I'll try to remember all the names. If forget, please excuse me. Now I remember Pragyans, Abhishek ji, Gayatri, Acha, Sandeep ji. Yes. What is pleading? Any other than everybody agrees to Sandeep? Plain and written statement. Excellent. What else? To plead. Yes, excellent.
How advocate represent his case.
Okay. How advocate represents the case. Okay, let's accept it. Then pleading, let us understand in a very simple manner. Whatever you put forth in a given format to get the result is pleading. I want something for which I have to write something, and whatever I put forth to get that is called pleading. Is that clear? So I gave an example of Pragyans. Pragyans, what he wanted? He wanted investigation by the police on the advice of Abhishek ji. Correct? As a lawyer. So what he wants? Investigation, intervention of police. So for which the information, the data, the facts, whatever he will put it in the letter in a given format, right, is called pleading. So writing down the same in a proper manner is called drafting. Is that clear? Let's understand in a very simple manner. That will help us. And we are discussing in a PG PG Department of Law. So we are not students. This program is, once you learn this, I would expect all of you to work as a trainer to tell it to your juniors, friends, not just juniors, you can tell it to your seniors also. Like we, in many sessions, we say that we might be junior to you. But when you are taking sessions, so not necessarily, you can learn it from your juniors also, right? So that is what pleadings. Now, what is conveyancing?
The transfer of the
transfer, okay, transfer of title, wonderful. Then ownership, possession, that is conveyancing. For conveyancing, again, what you write in a given format to present before an authority who will do the work. Here in court, you will get some result, get your prayer. Here to do the work. Or that is called conveyancing. Give an example. Sell deed.
Gift deed.
Yes.
Mortgage deed.
Right? Clear? Now we'll take a pause here. We'll see what could be civil, what are the civil pleadings, what are the criminal pleadings, then conveyancing, then we'll come to format. It's very easy. We were discussing, with all respect, madam, please excuse us. Why do we require 30-40 classes for drafting pleading? It is just 2 hours work. Then we have to do the exercise. Then we have to keep drafting petitions. I would say that when drafting pleadings you are teaching, allow the students to draft and file applications. Send students to file draft, whatever. So I would request my brother Rajat to cover what are the civil pleadings and criminal pleadings and then conveyancing. Then we'll come back with the format.
Madam was asking.
Yes, yes, please.
Why do you study these two differently, pleading and conveyancing? What I mean to say is that, like you said, whatever you want to put on and you want to get it outcome out of it.
Yes, yes.
So why these two are studied separately? Is it because forums are different?
One answer. Second answer is, pleading and conveyancing, our intention is different. When you say pleading, our intention is get the prayer, which we may get, we may not get. And there is a procedure, will come. Wonderful question. Please, let's have a big round of applause. It's a wonderful question. That is why interactive. Because in pleading, I file an application before you. Ki, madam, you are the authority. You are the judge. I file an application. This is my case. You are not going to just give an order to me. You have to send notice. We'll discuss about the court procedure. Okay. There is always a question mark whether I will get it, even if my pleadings are excellent. But in conveyancing, both parties go together. Say that, sir, I am the right title owner of this property, or whatever I want to convey. Now, he is the person who is agreed to take it. This is our understanding. I want to convey this to him. He wants to accept it. Please register it. So there is a, what do you say, one forum is different, intention is different, the entire purpose is also different. That is why we use two different words, and of course formats are also different.
And there is a possibility.
Opposite party conveyance.
Exactly, excellent. There is no opposite party, both are in the same.
There is a possibility here, you may or may not get it, whereas there you go
Yeah,
and
we go and convey it. Okay. And if he says, no, I will not purchase. It's like a contract. I will not take it. Can I convey it? No. Can you register it? No. So that is why it's different. Okay. Now it's over to you. You just come say that what are the pleadings and all. Then we will come to format.
Do I need to stand up?
No, you can sit.
I like sitting and
Because of past experiences.
yes, probably true. Probably true.
Somebody coming from the bench will prefer to sit and talk.
Yes, that in fact happened with me because I was sitting on the chair for like so long, and when I quit the job,
I'll just
and when I came, yes, and when I came to this side,
2 minutes.
I was actually facing difficulties carrying that gown for so long and walking because I did not know. I always wore the gown and sat on a chair. So I do not know, oh, is it even possible to wear that and walk? So it was coming off every now and then. So yes, and not because of that I want to sit and discuss. It is because it's a discussion that we will have. It is nothing that we are here to teach. I'm sure many of us seeing ma'am here, I mean, you must be having so many experiences that I am not aware of. So it can never be a one-way traffic. It can never be that I will say something and you will only take. Always I have an institution where I teach students how to become a judicial officer, and there also I only teach them one thing, that it is nothing new that I'm going to teach you. It's just that I know how to decipher it in the manner which is required to crack that particular exam, and that's the reason I teach you. But in the process, I am learning so many things from you. So always, when a teacher teaches, he's not actually teaching, he's building on his knowledge. He's adding on his knowledge. Or he's probably deleting from his knowledge. That will always be there. And coming to this drafting of pleading and conveyancing, before that, one important skill every one of you must get and every one of you must inculcate within you is that you must first develop the core concepts. The core concepts must be that thorough that you must be able to apply the same in order to get the desired results. Because more often than not, whether you are a judicial officer, whether you are a lawyer, whether you are a teacher, whether you are a corporate lawyer, whatever you will be at the end of the day, you will be required to solve a particular problem. And how to solve a problem? When you get a problem, you apply your knowledge, whatever that is there, and then you get a solution. And so if you do not have that required knowledge, if you do not have that required acumen, how much soever you may practice or how much soever you may try to inculcate later on, it will be very difficult to catch up. So this is the time you have to build on the knowledge first, and then once you have the knowledge, only discussing. So I don't even believe in this particular form of formats and all, because for me there are only one format of draft. If someone tells me that what is the format of a draft, I only say one thing. That you want to draft an FIR, you want to draft even if you want to draft a writ petition, even if you want to draft a bail petition, even if you want to draft a conveyancing, it is mainly consisting of 3-4 parts. What are the 3-4 parts? First is the forum before which you are applying. That means the court before which you are applying. If it is conveyancing, then also before which forum you are trying to register the same. That part is one important part that must be there. Then comes between which parties the said is to be done. If it is a pleading also, it will be X versus Y. If it is conveyancing also, it will be between the first party named this person and between the second party named that person. That is the second part. Third part is that brief facts in summary. That is, what is the problem for which you are trying to draft it. So that means if it is a pleading, then you will write the brief facts and then proceed to the other things. If it is a conveyancing also, what is your intention? What is the intention that you want to achieve? So if I want to carry out a rent agreement, then I must be having that intention that yes, I want to rent my flat out, and that's the reason I am entering into this agreement with some person. So that is the third part. That what is the intention or what's the brief facts of the case. Then coming to the solution. That is, what is it that you are actually before that the application of law. Before that the application of law comes. So you will have to apply the law or your knowledge to the facts that are there. And after that, the solution that you desire from it or the relief that you pray from it. If it is a conveyancing, then you will say that this is to be treated as a sale deed or anything. If it is a pleadings draft, then it will be the prayer that you will go for it. Likewise, I only say that there is one particular kind of drafting. Having said that, we'll discuss many kinds of draftings that are done, and that can be divided broadly into two categories when it comes to pleading. First is civil pleadings, second is criminal pleadings. Civil pleadings, what can be the example? Can anyone tell me? Plain written statement, well and good. Anything else? Yeah, keep writing. Civil, first is plaint. One form of drafting of a pleading would be plaint, because that is very important again, because without that the suit will not be instituted. You must have all studied CPC that suit is instituted on a presentation of a plaint. So plaint is to be first drafted, because anyone wants to come to the court, he has to present a plaint. Then in response to that, there can be a written statement that will be filed by the defendant, which will in fact aim at curbing or meeting all the demands that are put forth in the plaint. So written statement can never be drafted without the plaint. It can never be independent of the plaint. It has always to be dependent on the plaint. What are the next form of pleadings that can be done in a civil? Yes. So applications. So applications which can be of different types of applications, that you might want to add a party, you might want to delete a party, you might want to dismiss the suit for non-joinder of a necessary party, you might want to ask the court to reject the plaint, you might want to ask the court to return the plaint, you might want to amend your plaint. That's why so this comes applications and petitions. Applications and petitions. You might apply before the court, or you may file a petition for the court to do something. So broadly speaking, the applications can be many types. Application can be under many headings, because we all know that there are how many orders in CPC? Who can say? How many orders are there in CPC? And how many rules? Have you ever calculated how many rules? How many sections and how many rules? When I'm asking, I haven't calculated. I'm just asking you. Is that okay? Sir has calculated and saying, no, I haven't calculated. All I mean to say is that there are many rules and many orders. So it only gives presumption to one thing, that there can be applications or petitions under such orders and such rules whenever the case requires. So there will be applications, yes.
So sometimes in a civil suit, memos are also given. So do they also come under pleadings?
Memos also, yes, there will be also pleadings. Memos, memorandums, that will be given. Affidavits will be given. Those will be, so right, memos, affidavits. So you might have to file affidavits, because court will now, after the amendment of CPC, affidavit is also an evidence. Previously it was not so, but right now affidavit can also be termed as evidence. So under 145 of NI Act also, affidavit, in the form of affidavit you can file the evidence. So you might want to draft affidavits as well. What else can be done in civil pleadings?
So rejoinders.
Yes, rejoinders, and to that affidavit there can be counter affidavits. Counter affidavits can be done and rejoinders can be done. Rejoinders is what? Rejoinders is whatever you had earlier filed, you want to build on that. You want to build on that because you had missed out certain things, now you want to build on that. So you can file rejoinders. Counter affidavit, somebody has stated something before the court, now you want to counter that in form of a counter affidavit. That you can file a counter affidavit as well. What else can be done in CPC? I mean in civil laws. Set off and counterclaim, those will be more in nature of a plaint or written statement. So I would keep it in that category only because upon set off, what are you exactly wanting? In a written statement only you will want to set off the matter or you will counterclaim. So that will be again part of that plaint and written statement. Is there any other broad categories? All those will be narrow categories. Narrowly they will be again divided if you want. But broad categories I am speaking. Is there any other?
Caveat.
Yes, caveat can be filed. Caveat you write. That can be again, yes. As she is right, it can be application. It can be under application again. What else? I think these are the broad categories. Okay, yes. So sir, as a better way to probably address the same, that we'll have to decide the court first. If we are before a lower court, what will be the petitions? And if we are before the high court, what will be the petitions? If we will be before the Supreme Court, what will be the petitions? And draftings and pleadings will consider like that. So Supreme Court re kon file kariyo civil re? Yes. Supreme Court re kon file kariyo? Writs file kariyo padiyo. So write writs.
So since the category of the special petition भी ऐसे है.
Yes, SLPs. ମୁଁ ଆଗ ବ୍ରଡରେ କରୁଥିଲି ତାକୁ ଯଦି ଆପଣ narrowly if you define, so then you can be many things. Now we will discuss all the narrow categories also. So SLP can be filed before Supreme Court. What else can be filed? Second appeal. Appeals can be filed. Appeals. What else can be filed before Supreme Court? Yes. Supreme Court रे कौन कर रिव्यू कर पारे? Curative petitions. Yes, curative petitions more properly curative petitions. Yes. What else can we file in Supreme Court?
Any water disputes between states?
Water disputes between state. For that will be the nature of what? That will be nature of what? Is that an original jurisdiction? Yes, it's an original jurisdiction. So suits of the nature of original jurisdiction can also be filed in a Supreme Court. So you can write. So there also they will be in the form of what? They will be in the form of plaint. Because if it is an original jurisdiction, so it will be in the form of plaint only. Okay. Now coming to, I think these are the broad things that you can do in Supreme Court. Now coming to the High Court. In High Courts, what you can do? You can again go for writs, PILs. Writ PILs you can do. And then what can you file? You can file appeals, that is first appeal, second appeal, all of that you can file. You can file review, revision you can file. Revision you can file. And what else can you file? Reference can be, reference is a jurisdiction that can be invoked as well. What else can be done in Supreme Court, in High Court?
Election petitions are there.
Elections petitions can be there. Yes, election petitions. Contempt matters can be filed. Arbitration matters, the appeals thereof, they can be filed. What else can be filed? Yes, contempt in Supreme Court also. Contempt you can file in Supreme Court also. Transfer of cases, yes. That is important. That is, that can be filed in Supreme Court as well. That can be filed in Supreme Court as well. Transfer of cases in Supreme Court as well as in High Court.
And the Supreme Court death reference cases are also there.
Yes.
That you cannot file in High Court.
No, you can't. Death reference cases also you can file in Supreme Court but not in High Court, because only High Court has the authority to confirm the death, but they can't review the death penalty or anything. What else can be filed in High Courts? Okay, caveats can be filed in High Courts. Caveats can also be filed in High Courts. Caveats will be filed. Now coming to the lower courts, I think we have more or less discussed. That is the plain written statement, applications, petitions, memos, affidavits, counter affidavits, all of that. Those are required. Rejoinders, caveat, whatever is required, we may file them. So there can be petition. You can file. Oh, okay. These are the broad categories. Now coming to the criminal side. On criminal side, first we have to know how does a criminal case institute. How does a criminal case originate? Either by an FIR or by a complaint. These are the two modes, or there are any other mode? Suo motu jurisdiction is there also. Suo motu jurisdiction of the court is also there. So that can be also invoked, and court can suo motu even though there is no complaint, even though there is no FIR, still then a criminal case may function. So first is how to originate a criminal case. So origin wise there can be two things, that can be FIR and complaint. Suo motu jurisdiction we can't invoke, so we are not concerned with the same. Unless you become a judicial officer and you reach High Court and then you probably invoke suo motu jurisdiction of yourself. Other than that, there is no such requirement. Now coming forum wise, first is lower court. Lower court, what is required to be drafted? Complaint petition is of paramount importance, because if the police does not register your FIR, what is the remedy that is available to you? You will approach the SP, and if the SP also doesn't do this same, then you will approach the magistrate to, under which section you will approach the magistrate?
156(3).
Yes, 156(3) you may approach in order to require the magistrate to direct the police officer to register the FIR, or you may directly approach the magistrate under section 190 for a complaint, so that he can initiate an inquiry under section 20 and 202 and then take cognizance of the same under section 190 CRPC. So first thing required is complaint. Now coming to what all other things that will be required to file in a criminal court, for that which will required to be drafted? Bail petitions. These are our food. These are our food. So these you have to know. Kavu would be advocate ko, if you see ki yare toro sabudu maximum income koti, unless they are very specifically concerned with a particular NCL tre jo korchanti ki tax re korchanti, semanako to alga katha. Nale maximum ghar chale hochi bail re. So that you have to know in and out. Bail petitions. Bail petitions can be of, again, various types. Originally आपण file करि परिबे 437 रे or 439 रे, appealing the rejection or allowing of the bail. Allowing of the bail को भी आपण करिवे कि जदि आपण prosecutor ही गेले, काली exam देले और prosecutor ही गेले, then you will oppose that bail. तणु 439 you will approach again, or 439 रे आपण reject ही गेले भी ताकू भी approach करि परिबे. Anticipatory bails also you can file in lower courts. बहुत जन भावुथिबे काले जदि नहीं 438 रे डिस्ट्रिक्ट कोर्ट दे परियो ना नहीं, डिस्ट्रिक्ट जज दे परियो ना नहीं. District judge can also give anticipatory bails. Hence 438 रे आपण anticipatory bails also you will file. So these are the kind of bails that you will file. Written arguments also is something which you file in all stages of court, all stratas of court, all forums of courts, and seta pai kichi emti mandatory nahi. Written argument also, it is not a format that we can discuss. So basically it is, you were supposed to put forth the arguments orally, you are doing it in writing because court will not forget it now. Court au bhuliboni, ସେଥିପାଇଁ ଆପଣ ତାକୁ writing way ରେ ଦେବେ. So there is no format, yes, but written arguments you will file again. Bails ପରେ ଆଉ କ'ଣ, bail ହେଇଗଲା, complaint ହେଇଗଲା, लोअर कोर्ट रे आउ कोन ना आगो सुप्रीम कोर्ट स्टार्ट करिया. लेट्स स्टार्ट फ्रॉम सुप्रीम कोर्ट ओनली. सुप्रीम कोर्ट रे कोन करि परिया, क्रिमिनल कंटेम्प्ट हे परियो. सो दैट्स अ क्रिमिनल कंटेम्प्ट हे परियो. आउ कोन हे परियो, रीड जुरिसडिक्शन इन्वोक करियो. ता पई जहा दरकार सेटा फाइल करियो पड़ियो. केमती सुप्रीम कोर्ट रे को जुरिसडिक्शन इन्वोक करि परिया, क्रिमिनल केस रे habeas corpus. Yes, that is in fact I wanted to hear from you. Habeas corpus jurisdiction. अच्छा, lower court रा habeas corpus jurisdiction अछि कि? CRPC रे कोथरे? I wanted to know. हाँ? Good. 97 is in fact a mini habeas corpus. 97 CRPC. So आपण जदि 97 CRPC पढिबे, that in fact give wide power to the magistrate to produce the body of a person in case he has been kept confined or he has been missing. So mini habeas corpus is given under 97 CRPC. But आमे जे सुप्रीम कोर्ट रे थिले रिट आगो गोटे करि परिबे, जोटा कि habeas corpus रिट आपण करि परिबे. तो ता पई जोटा दरकार करले. नेक्स्ट आउ कोन करि परिबे, bail appeals you can file in supreme court. Bail appeals you will file. High court भी bail reject कर देला. What will you do? You will go to the supreme court now. सुप्रीम कोर्ट एंटिसिपेटरी करि परियो ना नहीं करि परियो. बहुत जन कहते जे नाही दिया हेनी करि परियोनी. सुप्रीम कोर्ट भी करि परियो. बहुत जन भाबियोनी जे नाही काइना सीआरपीसी रे पढले कोन लिखा है, जहा पावर हाई कोर्ट करि परिबे कि को लोअर कोर्ट करि परिबे, सुप्रीम कोर्ट रो बाय वर्च्यू ऑफ दे हैव द इनहेरेंट पावर बाय वर्च्यू ऑफ बीइंग द सुप्रीम कोर्ट. सो जहा हमें तळ कोर्ट रे करछे सब हमें हाई कोर्ट सुप्रीम कोर्ट रे डायरेक्टली करि परिबे. नॉट दैट डजंट मीन कि आपण जुरिसडिक्शन को ओवरलैप करके पळे आसीबे, ता माने गोटे जुरिसडिक्शन को मिस करके डायरेक्टली आपण सुप्रीम कोर्ट को सब छोट छोट जिंस पे सुप्रीम कोर्ट करे. बट सुप्रीम कोर्ट आल्सो हैज द जुरिसडिक्शन इन ऑर्डर टू मेक श्योर दैट जस्टिस इज डन एंड जस्ट खाली गोटे प्रोसीजर कैन नॉट बी द हैंडमेड ऑफ जस्टिस. तो सेटा हला आपण बेल्स भी फाइल करले, एंटिसिपेटरी बेल भी फाइल करले. आउ कोन करिवे फाइल, क्वॉशिंग ऑफ केसेस 482 पे रे आपण क्वॉशिंग ऑफ केसेस. अच्छा, at this behest I want to discuss one thing. Who thinks that inherent power खाली high court and onwards अछि और lower court रो inherent power अछि ना नहीं, मते स्टे आंसर सिविल रो अछि, क्रिमिनल रे
से अछि सर
अच्छी तो ସେମାନେ डायरेक्टली प्रेफर करते हैं हाई कोर्ट को डायरेक्ट अप्रोच करते हैं.
So that means quashing पे हमें अप्लाई करि परिबा,
सेशंस रे अप्लाई कर परिया. बट से माने मोस्टली से माने फ्रूटफुल रिजल्ट मिलेनी तो सीधे डायरेक्टली अप्रोच कर.
सर डिस्चार्ज से कोई मेरे पास
नो डिस्चार्ज तो पूरा दे दिला. इनहेरेंट पावर से इनहेरेंट पावर टा माने कोन आगे जानियो पड़ियो. इनहेरेंट पावर माने होचे एवडा पावर which is existing in a court because of the reason that it's a court. It is not because of anything else. Just because it's a court, it has certain powers. Those powers are called inherent powers. And 482 रो गोटे लूज इंटरप्रिटेशन होची जे हाई कोर्ट only has inherent powers. But that's not the case. 482 says nothing will limit the inherent powers of the high court. Nothing in this CRPC, nothing in content hereinafter will limit the inherent powers of the high court. That means only one thing: high court's inherent power are unlimited, whereas the inherent powers of the lower court are there, but they are limited. And limited to what? If there is a necessary provision in CRPC, then that will be limited to that, and the lower court cannot override that provision. But if there is no necessary provision in CRPC to address a particular issue, then the court can very well go for inherent power, like quashing. क्वेश्चन जो फोर आपण कहउचंती क्वेश्चन रो कोठी गोटे देछि कि सीआरपीसी रे कोठी क्वेश्चन देछि से जहाँ कहले दैट इज ट्रू सीआरपीसी डिस्ट्रिक्ट कोर्ट भी चाहे कर परिबो बट नो डिस्ट्रिक्ट जज विल एवर टेक दैट रिस्क बिकॉज दे थिंक वी आर असर्पिंग द पावर ऑफ द हाई कोर्ट आर वी असर्पिंग द पावर ऑफ द हाई कोर्ट बाय डूइंग दैट नो जेमि एंटिसिपेटरी बेल रे बहुत जनकर जुडिशियल कर मुंड रे थाए जे नाही एटा तो हमरो एटा हाई कोर्ट को दवा कथा हमें दबु नो सेटा तो डायरेक्टली तो मु देछि सेटा तो डायरेक्टली दे के दो नांती अपन इनडायरेक्टली जदी पावर कोर्ट मिलथिबो डिस्ट्रिक्ट जज काई देबे जुडिशियल रे मु थिली आपण कहउछि इट इज नॉट समथिंग टू बी वेरी प्राउड ऑफ वन लैक इज देयर कि वी आर अफ्रेड एंड टू डू व्हाट वी आर अफ्रेड टू डू जस्टिस दैट इज वेरी बैड एज ए जुडिशियल ऑफिसर योर ओनली जॉब इज टू डू जस्टिस and to do justice if you are afraid whatever may be the situation whatever you are doing if it is within the purviews of law I don't think there is any need to be afraid of anything डरिवार नहीं के तो किछि डरिवार नहीं हाई कोर्ट हेले कोन हला मु जदी ठीक करछि I as a magistrate have granted it's a public forum I am saying I as a magistrate have given bails in sessions tribal cases so you may say now ki how have you exercised the jurisdiction but I was not taken to task because what I did was within the purview of law so that means 437 re kochi case has to be made out prime facie case has to be made out first sessions tribal offense अछि ताकू देखि जदि मु बेल रिजेक्ट करबी ताल तो सब बेल रिजेक्ट करबी जेमति भुवनेश्वर रे गोटे केस हेतला कोन गोबर माड रे 307 गोबर मारथिले ता धरे 307 केस हल इज इट इन फैक्ट अटेम्प्ट टू मर्डर माने सेमतिया गोटे ग्रेविटी रो गोटे ऑफेंस होबे दरकार जोटी अपन लागबो जे नाही मते सत्य रे मार दै थांदा आज मु मरि जाई थांती गोबर मारले कोन मरि जाई बोल लागुची कि गोटे कहबो जे नाही ता गंध रे मरि जाई थांती बोले सो इट हैज टू बी रीजनेबल okay so inherent power we all have kehi court because of the reason that it's a court जेमति आमे हमर inherent power कोन as a person we have certain inherent powers if somebody touches your body you will push it और कि आपन को हर्ट करूची आपन तो कहिबे आपन के गाली देला आपन ताकू गाली you give it back to him जो प्राइवेट डिफेंस that is your inherent power so कोर्ट रे भी सेमति अछि कोर्ट कहबे बसे कि जोता पिंगिबो कोर्ट कहबे जे नाही आज्ञा मो पर तो कंटेम्प्ट पावर नहीं तो मु किछ कर परिबे नो कोर्ट कैन स्टिल डू समथिंग अबाउट इट हाउ 228 रे आईपीसी रे जुडिशियल प्रोसीडिंग को इन्फ्लुएंस करछि बोली कर परिबे तो पॉइंट आसला एठी हमें जदि आसिला हाई कोर्ट रे कोन आउ कोन करियबो हाई कोर्ट रे अपील्स तो करियबो कहले रिविजन करियबो कना जोटी सब केस रे तो अपील नथिबो जो थरे अपील नथिबो सेतरे पण रिविजन पुनी करिवे राइट आउ कोन करिवे ई सब जहा एठी कहले रिजॉइंडर एफिडेविट काउंटर एफिडेविट से सब भी सेठी दरकार हला petitions various applications those will be again there बहुत गुडे petitions पकेबे बहुत गुडे applications पकेबे ट्रांसफर ऑफ केसेस पे पके परिबे क्रिमिनल केस भी ट्रांसफर करिया पे पके परिबे आउ कोन पकेबे आउ कोन दरकार हिरे ड्राफ्ट करिया को हमको okay broadly these are the things whatever I missed out sir will say आउ लोअर कोर्ट रे हमें जानले कंप्लेंट करि परिबे एफआईआर तो करी की इनिशिएटिव हबो तापर there will be again other petitions there will be bail petitions there will be anticipatory bails all of that we discussed probably yes so these are the broad categories of drafting of pleadings that we'll do and now coming to the drafting of conveyancing ro kon संधि हे परिबो सेल डीड आपण करि परिबे
once a person is lost in custody or
yes
convicted also
yes
so want to go to meet attend my mother's funeral or something all those things also will be
yes those will be under petitions तो तारा गोटे ही हमें फॉर्मेट जदी जानिबा ताला कोर्ट रे फाइल हो तो पिटिशंस ओनली देयर कैन बी एनीथिंग जोडा कि सपोज सीआरपीसी रे नाही ता पई भी हम जदी कि छोटे रिलीफ चाहू छे सेंता भी पिटिशन फॉर्म नहीं पकेबा we will file that in the form of petition only suppose we want to provide certain good food to a jail inmate because he is ill and he can't digest the food that is being served there so you can file a petition though there is no specific jail manual re bhi nathibo still then you can file a petition So all the petitions will be
Somebody is not been taken to the court when they are supposed to, under some plea or other, and is not able to appear before the magistrate.
Yes.
Okay, so that also can be a.
So you're saying the 15 days mandatory producing before
It's
the.
not being done regularly.
Absolutely. For that, there is a violation of a clear rule. So you can file a petition for that as well. You can file 167 clause 2 petition. You can file for releasing the accused if he is an under trial prisoner and he has not been inside. He has been in custody for 60 days or 120 days as the case may be. 90 days nahi. Odisha mein heda 120 days.
And the search and seizure also, some they kept the things and not returned.
Yes, all of such things you can. 457 petitions you can file. 457. What is the 457 petition? That is also again a bread and butter for trial court lawyers. That is releasing the properties intermediately. That is pending trial. If you want to, if a property has been seized and you want to release that property, then 457 petitions you can file. Okay. Now coming to the conveyancing part. Conveyancing रे आपण कौन करि परिबा? बहुत रेगुलरली हुए रेंट एग्रीमेंट होची बेसी फ्रिक्वेंटली रेंट एग्रीमेंट हैला सेल डीड्स हैला मॉर्गेज डीड्स हैला आउ कोन हे पारे लीज हे पारे आउ कोन विल हे पारे गिफ्ट हे पारे हाइपोथिकेशन हे पारे प्लेज हे पारे आउ कोन हे पारे बहुत अच्छे कन्वेंसिंग बहुत अच्छे आपण मैरिज रजिस्टर करिया पे चाहउचंती ता पे भी गोटे सर्टेन कन्वेंसिंग इज रिक्वायर्ड कने सेठी गोटे आपन एप्लीकेशन भलिया गोटे देवा पड़िबो जॉइंट एफिडेविट टाइप रो जॉइंट एफिडेविट यू वांट टू सबमिट दैट आल्सो यू दैट इज रिक्वायर्ड टू बी डन इन कन्वेंसिंग सो कन्वेंस यस adoption भी कन्वेंसिंग रे जीवो adoption but again adoption for that to happen that will be the court has to intervene and make sure that it is valid adoption. So you can't just अपन अंति निज निज भीतर डिक्लेयर करी कहि परिबेनी जे adoption हे गला आज right जमती will how does it come into operation again probate करियो पड़ियो will कुछ अपन probate न करतनी से परंतु सेटा किसी नुआ will करी घरे रखी that is of no use. Okay, so these are the broad categories of conveyancing. Now sir will say the formats thereof. I hand over the rights to you.
मुझे डाई कर
You please. You are a lawyer in the truest sense, so you will. I am still a judicial officer inside, perhaps.
We all are lawyers. We all are law students. That's the best. Okay. So before we go to the formats, we'll take a short break. And a break not outside, inside. Okay. ये सब अपने पास जो सब है बोर्ड बैगेजेस सब साइड में रख दो. Please close your eyes. Please close your eyes. Now, sit there and close your eyes. फिजिकल आई जो है उसको बंद कर दो. मन में अगर कोई किसी का त्रिनेत्र किसी का है, किसी का थर्ड आई है, किसी का कोई इंटेलेक्चुअल क्वेश्चन है, उसको ओपन रख सकते हो. प्लीज क्लोज योर आइज. जस्ट टेक रेस्ट फॉर 1 minute, then I'll give you some instruction, follow that. We discussed that what we want from this profession, session, what I want personally. So we discussed about setting the radar. Third, whatever I will do in the profession, there is a basic requirement I should know drafting. Then what are the various types of petitions? What are the various types of documents that are generally used as a tool to excel in the profession, either to earn or to learn? Keep closing your eyes. Just concentrate it, digest it, then we'll go further. Otherwise, it will be monotonous. Okay, this is a kind of meditation. Whatever has been discussed, we are putting it to our hard disk, storing it, then we'll refresh it. Then if it is fine, we are comfortable, then we'll go further. Correct? Then we'll come to, this is what the theory, then we'll come to the execution part. Okay, so keep closing your eyes. With now this 2 minutes is a relaxation process. Okay, so that we'll take a rest, our brain will not get exhausted, then we can go to the next step. Next step is more fully about exercising the brain in understanding the execution, how to put it in a format. What we require, we discussed. What are these options, what are the various types of petitions, we discussed. Now how to put it in a format, that we will discuss. Okay, now let us put this question to myself. Put your question. Are we ready to go further or we want to take a break? If you are ready, then we will go. Okay. Otherwise, we can take a break. It will take just 15-20 minutes, right? There is no problem, there is no harm in smiling. You can close your eyes and keep smiling, not a problem. I said smiling, not laughing. Okay, slowly you can open your eyes. It's not like a resting. What happens, I'll tell you. Everything goes to the brain, okay, and the brain gets adjusted with our eyes. Okay, and importance of eyes we will discuss after the break. After this we will have a code proceeding with very quick. What is the code proceeding? We'll have a quick discussion after the format. Then we'll take a break. Then we'll go for a very open, a lighter discussion where we'll discuss about importance of our brain, how to remember, memory techniques, and how to excel in the profession, economics of profession, management of profession, right? So can we wipe it out, erase it? Kar sakte hain na? So there are two things. One is smart work, another is hard work. Sir did the hard work because he is very erudite. So let's have a huge round of applause for him. He shared his experience. Photo lena hai? Le lo.
He is a very good.
Everyone is very good. Photo. Muh nahi ho. Chidam photo de. So because he shared his experience and what are the petitions and which petition is more important, which is are you taking our pictures or not? Only that I see everybody is taking pictures of the board. अपना भी ले लो भाई. इतना भी खराब नहीं दिखते हैं.
Your pictures will be second mandatory.
Why? I am not going to die. Mandatory. Okay. Okay, we'll do the smart work. We will understand the format in which all the petitions can be put. So what are the components? In order to learn the drafting format, there are basic components we need to understand. Suppose, what's your name, sir? Sir, बैठ के बोलिए ना sir, please, आराम से. Ramakant. So I went to Ramakant sir for some consultation. He's an advocate. Okay. What will I do? Please understand in a practical point of view. Okay. मैं जाता हूँ सबको. I mean everybody understand English, Odia? No, otherwise Hindi. Okay. English. So I go to Ramakant sir for some legal advice. I have a case. Okay. Let's say one of my friend. Nobody's friend should be get arrested. Let's say one of my friend is accused of some case. I want to file a bail application. For example, it's very easy, so we can go ahead. So what will I tell him? I will tell him a certain fact, correct? I will tell him about the party, who has filed the FIR, what has happened, then what he will advise me. Whether he has been arrested or not arrested. Either, yes, excellent. So if he is arrested, then you go for regular bail. If he is not arrested, then go for anticipatory bail. Okay, we want to go for a regular bail. The next question will come. Sir, I want to, because he is already arrested. Next question will come. What are the offences? Okay, then apply for the bail. Excellent. We'll apply for the bail. That is called regular bail. ओके, लेट्स नॉट गो टू द प्रोविजंस, फिर वो मॉडर्न हो जाएगा, फिर आई विल गो टू स्मार्ट वर्क. प्रोविजन सर बता देंगे हमको भाई, आई डोंट नो दिस प्रोविजंस. नाउ नेक्स्ट क्वेश्चन विल कम. Sir will advise me, you have to file a regular bail. Next question is, we have to approach the court. Excellent. Then
Which court?
wonderful. Which court? So first is fact, second is party, third is which court, which forum. Clear? Then
Which advocate?
which advocate? रमाकांत जी हैं. आप तो सुप्रीम कोर्ट में बैठे हुए उधर, सुबह बोल दिया मैंने. SLP करने आपके पास आएंगे. So चलो एडवोकेट. देन
Did you case listed?
case register. Okay, certain documents, you are coming to documents. Okay, now advocate, you have to have a document that is called a vakalatnama. I have to give him a vakalatnama. Sir, you appear on behalf of my friend, he has to sign it, right? So what are the four then components? First the forum, second the fact, third the party, fourth the documents, FIRs, vakalatnama, whatever. Fifth, prayer. Wonderful. What do you want? Sixth, affidavit. Okay. Seventh, document में आ गया ना. कितने बार वकालतनामा दोगे? We lawyers feel happy when you see वकालतनामा. Fees. Yes, wonderful. Excellent. Come on. Yes, clap. Right. Thank you for understanding us. Many do not understand fees. Then one more important is, I just said it in a lighter note, but nobody, point of law. Then yes, what's your name, sir? Last? Aniket. What else? Grounds. किस ग्राउंड पे बेल लेना है? नहीं पूछोगे? So grounds. Okay, so let's have a quick recap. One, forum, the court. Second, facts. Then, okay, prayer. Then, fact and point of law. Correct? And grounds. Okay. Now, if we put it in organized manner, it becomes a good draft. Okay. Correct? Like preparing a good dish. Okay, he is a foodie and a good cook. So what we do, we have to put it in right format with proper arrangements. Correct? Let's go. हम खुद लिखेंगे इसको. এটা ঠিক উল্টে হবে কি এমতি সিধা করে হবে না? না এইটা রাখি দাও, এইটা রাখি দাও না. হ্যাঁ, এমতি ভার্টিক্যাল রাখি হবে. हाँ, is that visible? Huh? ना संदीप is there. गिरने नहीं देगा, झुकने नहीं देगा. Okay, so now अच्छा अलग कलर यूज करियो नहीं? अच्छा परमानेंट. अच्छा, okay, not a problem. Move. I'll write it. First, just don't write. First is the format, and first we said what is the forum, which court. So that is why we write court of, like that, or before. Correct? First. Second, now you discussed recently either no, I'll come. I said, you said the ingredients. Now कब किसको डालना है, I'll tell. You can tell, not a problem. But बताओ, डालो मत तुरंत, फिर खराब हो जाएगा. You discuss now that jurisdiction, original jurisdiction, appellate jurisdiction. That is optional. You can write. It's a original jurisdiction or appellate jurisdiction, whatever. You can write it. It is an optional. Okay. Sorry.
They can take a snap afterwards.
Sir, कौन करिया एती जगह रे सारी बार अछि. बुझिपारे कि जदि छोट अक्षर ना ना छोट अक्षर इम्प्रेशन टा आपण मन में रहीगला ताले काम बहुत बड़ होगा करेक्ट अच्छे बुझा हो तो बुझा पड़ुची तो ताले छोट को न लिखले भी चलो ओके पूरा सारी बात गोटे पेज रे ना वी डोंट हैव सेकंड पेज ओके सो नेक्स्ट इज यस wonderful no case number will come case number the case number will help in decide will number will come subject to the condition what nature of case you are filing right so case number nature of case for example WPC BLA PL writ appeal or SLP civil like these are the case nomenclature please understand you have to decide the nomenclature you cannot decide it is the rules provided under the prescribed law or the rules what would be the nature what would be the nomenclature of the case suppose you are filing a writ petition it has to be WPC. Suppose you are filing a special leave petition, SLP. Suppose you are filing a review application, review petition number. Suppose you are filing contempt, CONTC. Suppose you are filing a civil suit, CS. Again, civil suits are been categorized, III. Suppose you are filing a money suit. In Odisha, there is a civil CS number 3. In other state, there is a money suit number this. Right? So nomenclature. Then year. I will go slow and little detail. Okay. Now case now court is over because this will lead to court proceeding. The next session, you will have a complete package. Next day, tomorrow morning, you can go and practice. We will try to do that. Okay. So next is
In the matter of
okay. No. पॉइंट ऑफ लॉ पहले लिख देते हैं पहले पॉइंट ऑफ लॉ लिख देते हैं which under which provision of law you are filing the case correct why we write it because see drafting in a proper format why nobody is asking format क्या चाहिए मेरा प्रॉब्लम हुआ है you are the judge you have to give me you are being paid by the government it's a welfare state मैं क्यों इतना झंझट में घुसूं correct to bring easy or what do you say fast okay to fasten the process smoothening the process so point of law in the matter of we say an application under section okay or under article असुविधा होची टिके असुविधा चलो मत भी टिके होची तब मिसिकी करेक्ट करेक्ट मी व्हेनेवर आई गो रॉन्ग
I would want to add something in the wordings of Mr. Justice Kadju se eti kahithile je what is the object of sir asked no I can simply go to a court and ask ki this is the my problem you give a solution. So he said कि make the judge eat out of your hands. That means ताकू खुए दियो तमे. Judge निजे तो खाई परियो, but निजे बाची की खाइला बेले को time लगियो. But ताकू जदि गुंडा आपण करी की खुए देवे, खाई देला साइंस. So this in fact. खुए देवे माने with law, facts, forums and procedures and format. Yes. Not other thing. तामने नो जे आपण पैसा कहियो true. This is going live. Please save us from contempt. No ill intention. We're trying to in a lighter note so that everybody will smile and laugh. Okay, we are learning. See, there is a very good thing that in an academic forum, in a research, and as a student we can say we can do everything. But when you are burdened with responsibility and positions, then you are restricted, right? I doubt you could have said the same thing few months before.
Okay. Then next, in the matter of, then you can write, see, to make him feed or to help him know what is your prayer, what you want in brief, you can put it here. An application challenging an application for this, or a petition for partition, or a petition for injunction. You can write it, not a problem. A petition for time, a petition for interim bail, an application for whatever you were discussed, appointment of commissioner, an application for change of advocate, whatever, you can write it here. Then here in the matter of, here you can write parties. Am I clear? Don't write, just listen to me, then you can click a picture. Don't write it, Parties, let's say A, B. So here the parties nomenclatures are also directly related to the case. Suppose there is an appeal. Who files an appeal? Appellant. The parties will be appellant. Okay. Second, I'm coming that. Respondent. So first party. So you file a petition, petitioner. You file a civil suit, plaintiff. You file an appeal, appellant. You file an original application, applicant. Right. So depending upon the forum and the nature of case, the nomenclature of the parties will be decided. Is that clear? And the parties, when you write with the detailed address, age, son of, etc. Right? Okay. Then you write VERSUS. What does it mean?
Against whom?
Yes. Against whom you are filing. Okay. Now AB, let's say X, Y. Same. Is that clear? Petitioner, or it is respondent, or opposite parties. Clear? Now your first page is over. Now very important. Sometimes we write who files an application. Now this is the case where A versus B or A versus X. In that case, while the case is proceeding, first A has filed it, admittedly. When the case is proceeding, in between B can also file a petition, C can file a petition, third party can file an application, opposite party can file an application. That is why, to again what sir said, to make it easier, we have to write here an application or a petition filed by petitioner, opposite parties, respondent, whatever. So he sees that and says that, okay, this is filed by so and so. This is called cause title. Cause title. The title, this is called cause title. Who are the parties? Right? Then who has filed it? Okay. Then we write most respectfully Swet. Most respectfully submitted. Swet is submitted, right? Clear? Then comes very important aspect. Here I'll mark a star mark. In High Court and Supreme Court, we address the petitions to the Chief Justice. Correct? In all other courts, subordinate courts, each court receives the file in his own registry. Now, very technical thing you need to understand. In High Court and Supreme Court, the registry is headed by the Chief Justice. So you address it to the Chief Justice. Here you write to the Honorable Chief Justice and companion judges of this Honorable Court. Am I clear? So I would again request, please listen to me then, because I am not writing anything. Okay, please listen to, then you can write it. So you file it in the registry, which is the central, what do you say, office of that particular court. So you address to Chief Justice. In all other court, you may address to the head of to the presiding officer, but When you write, suppose you file it in civil judge court. Civil judge has his own office. So you don't have to write it to Chief Justice. It is his own registry. So here you may not write this to the Chief. Are you getting my point? Am I clear? Or it is becoming very difficult to understand, right? Then comes the actual essence of drafting. What is that? You have to write the fact. You have to write the facts. How you start the facts? I will break the facts in 3 aspects. I don't know, while saying breaking it might get 4 aspects also. First aspect is, first you write why have you filed this case and what you have challenged. It will be an elaboration of this thing. First paragraph. That is why sir said, na, you want to make things easier for the judge. So first paragraph has to be, art of drafting is, first paragraph has to be very precise and what you want. An application by the petitioner challenging the inaction of government so and so department in doing this. And with a prayer to quash this. Documents, right? Clear? Or an application for bail of the petitioner who is in custody since such and such date and has been languishing in the jail without any fault of him, so and so. The court gets the gist from the first paragraph. Next you elaborate. Next paragraph you elaborate with very important aspect of drafting is chronological events, date chart or a chronological sequence of event. You would say, suppose there is the example of, let's say, partisan suit. Okay, A has got 3 sons, A1, A2 and A3. A has purchased 15 acres of land in Bhubaneswar. A has adopted a son named A4. Before making any specific arrangement for the properties, A passed away on such and such on 2000, let's say in COVID to 2020. The adopted son claims to share the property of A, which are left behind while after the death of A interstate. Interstate means without making any arrangements. A1, A2 and A3 are not supporting him. Sequence, suppose I would say like this. First paragraph. The plaintiff, being adopted son of A, files a case where 15 acres of land purchased by the ancestor, then you write, then also we are accustomed, we are putting it in order. So you will put it in destructive manner. In 2022, there was a fight between A1, A2 and A3 and A4. In 2020, A passed away. So you don't know who is A, who is A1, A2. So here you have to put it in chronological order. Right? Which includes the events and explaining the parties. Are you getting my point? Who is plaintiff? What is the relationship between A and X? You have to explain that. Now am I clear? So if I put it in this way, first is the fact in gist or in brief, then chronological order, then you have to write the relationship of the parties. While I am writing, you can write. But when I am looking at you, please look at me. I'll feel good. Okay. Then very important. There is now what we know now? We are before the court. We know the provision of law. We know what we want. We have communicated this. Now very important question. You are the judge. What will you ask me? Prayer. Okay, then? Any other relief. Then? The documents, very good. Then? Wonderful. Why? I always say now, who, why, how you have to put it. Why are you coming now? What happened? So very important, you have to put it in a specific paragraph. Cause of action. Your action is, I'll put it in this way. Your action is filing a case. What is the cause? Why have you filed this? What happened now? That you have to write. Correct? And in between, you can annex the document. Or at the end, you can make a list of the documents. No problem. Is that clear? Then after the cause of action, directly you come to the grounds. Some make a specific heading, then they give grounds. Or else you can put it in paragraph form. So if you break the body of the drafting part, what is it? First, this is the first page. First is no. That first page. First page will review. Then this is the body, main person. What is that? First is fact and gist. Explain the parties. Relationship, yes. Or you can put it earlier also, not a problem. Then cause of action. Then grounds. This has happened to me. This is the law. This is the fact. This is the cause of action. Now come grounds. These are the grounds. The grounds can be factual grounds. Grounds can be legal grounds. In the grounds, madam has put a right question. You can put all your research work. In the grounds, you can take precedences. Why research is important? What has happened in other courts, in previous matters, similar matters. You can put your research here. Okay? Now, at the final stage, you have to make the prayer. Right? So, you put it like this, prayer. What do you pray? Let's say, how you pray? Om Bhur Bhuva Swata. Or Gododhari Gaya. No, Kano Kunde ki bhi karunti. Yes. What do you pray? How you pray? What relief you want, you can put it in points. That's why, on what basis? Now, you are getting a final opportunity to make the prayer. On what basis? In view of the facts and circumstances mentioned above. Right? The humble petitioner or appellant, considering the grounds taken above and the judgment cited, this honorable court may graciously be pleased to allow 1, 2, 3, 4, 5, 6, 7, 8. Jabi. Okay? Clear? And for this act of kindness, as in duty bound, shall ever pray. The more humble you can write, that is your art. But this is the format. Correct? Now, just below the prayer, you have to sign. Who signs it? Generally, advocates sign it. And the entire, then affidavit.
This one is the verifications.
Affidavit or verification, there is a difference. Chalo. Okay. Chalo, no problem. Now the petition is ready, it wants to be filed, this wants to be filed. That's why, chalo, file kar do mujhe. Okay, so in affidavit, why do you give affidavit and verification? The client, I had been to Ramakant sir. Now, Ramakant ji has given me this draft. He has signed, okay, sir, this is your fact, I have written it correctly, verified, yes. This is your parties, verified. These are the cause of action, verified. These are the judgments, I have done the research, okay. So the party himself has to verify. And we will say that these facts are correct. I am signing it, please file it. So you put it in affidavit format or in verification. In affidavit, you have to swear the affidavit before the oath commissioner or before the notary public. Or in verification, you don't have to swear it. You just have to verify and state that these facts are correct. Clear? And the affidavit, you have to say that this has been drafted as per my instruction. I am so and so, and these facts are correct. Clear? This is what? Simple format, and you put all the provisions. Suppose, yes.
Affidavit doesn't mean that the client, what he or she has said to the lawyer, that is true to its very nature, and that he is signing as an affidavit, and in verification, what the lawyer has written in the whole claim, that I have verified it and that I am signing. Like, is there a difference? Or?
A slight difference, thin line of difference. You have to verification and affidavit. You swear, you say that the facts are correct as per my instruction. As stated by me. Yes. And verification is also the same, that I have verified that the facts are correct. Who gives the fact? It is lawyer doesn't have the fact set up. उनके पास तो box में नहीं होता है. आप आए तो इसको निकाल के दे दिए. नहीं. You only give the facts, then only lawyers put it. Okay. The same.
There is a slight difference, if I would like to add, between the affidavit and verification would be that for verification, the court cannot take probably any action if there is any mistake in the same. But if there is an affidavit and if you have falsely deposed something before the court, then actions can be taken against you as per the necessary laws that are there. So that is the thin difference that is there, but the object is same. Object is that, as sir said, that to make sure that whatever I am saying, I stand by the same.
Right. So whatever petitions we discussed just few minutes before, you put it in the format. Civil suit, injunction application. So say injunction application before the civil judge. Original isko hata do. IA becomes interim application. Am I clear? Yes, sir. Then in the matter of an application under which provision? 39 rule 1 and 2. Very good. Then you write an application for interim order or interim injunction. Clear? Then party naam ho gaya. Then you say that what is the fact? Grounds, prayer, bail application. Same. What I have seen in many books, in many materials, they give different formats for different. There is no harm. That's not wrong. But if you can put it in one format, what is the problem? There will be slight changes. I'll put a caveat here. When you file in a particular forum, please go and see the rules of that particular forum. Sometimes this is the basic format, but sometimes it is slightly modified in terms of, let's say, pagination, in terms of, like in Supreme Court, we suppose you have a bulky volume, you have to make volume, 200 page, one volume, 201 page, for one page you have to give another volume, another compilation. So whenever you file, suppose you're filing before the National Green Tribunal, this format will always remain in all courts, at least in India. But when you go and actually file it, please verify the rules of that particular forum, most likely the tribunals. Okay. And in different high court also, they have specific notifications for facilitating the drafting and the court procedure. Like recently, yesterday, Odisha High Court has come up with an amendment, notification that here, after all this thing, you have to give 2 more pages. What is that? One is synopsis. That whatever you write here, it would be in a separate page with a heading of synopsis. It's all same, no? And there will be a separate page with a chronological date, that dated such and such. So this person was born, this person had taken admission. So you have to make a separate date chart. Of course, you do it while you argue the matter, right? So this is a common format for your academic purpose. But when you actually go for the filing it, this will remain always. But please keep it in mind. Verify the rules. There might be some slight in Odisha. Let's say previously Odisha Administrative Tribunal was there, SAT, State Administrative Tribunal. There, for multiple prayers, you cannot have one application. For multiple prayers, you will have to have multiple applications. These are the rules. You cannot say it. anything. Okay? Is that clear? Any doubt? Then we'll pause and then we'll go for the court proceeding. What is the time?
Sir, which book can one
Which book for drafting? Drafting, pleading, book kaun dakar? There are several books. There are several books. I follow one. D'Souza is there. D'Souza, there is a book, and there are any book you can follow. That is not see drafting, pleading. There is no requirement of a book. With all respect to the authors, learned authors, those who. No, I would say don't go for books. Read various petitions. You can ask us. We will supply the petitions with a assurance that you will not disclose the names of the parties, because it will be very difficult for us to erase the parties and send it to you. Don't disclose the name of the parties. Then you read the. I would suggest rather than books, reading more number of petitions will help. Good petitions.
That is in fact the catch. Once you know the format, this is the only thing that you need to know, as sir lucidly told. And after that, your job is to see as many as possible. ମାନେ ଯେତେ ଆପଣ possible ହେଉଛି petition ଅଲଗା ଅଲଗା various senior lawyers, if you can get hold of them. If not, sir is there. Sir has email. No, but he has a gamut of drafts that he can supply. If you read at least, make sure if you at least read each kind of draft, at least 10 formats of them, 10 number of each drafts, I'm sure your doubts will be
very easy to remember. Which forum, what is the law, what do you want, who are the parties, what is the gist, then what are the chronological events, then you write your cause of action, why have you come, what's your name? Subra. And then you write what are the grounds, then you write the prayer, then affidavit, khatam. If you write this, people feel that drafting is very difficult. I must mention that in my second or third year of practice, I was given an opportunity of drafting a petition by one of our seniors for the first time. And he said, can you draft it? I said, give me the file. He gave me around 12:30. In the evening, the draft was ready. Then he started giving me drafts almost every 2-3 days. He gives me a draft. So in a week, I used to draft almost 20 petitions. Okay. And that time I didn't know that this is the format. No. I was not having that knowledge. What I used to do is, I used to only arrange the documents. Like somebody said, documents. First trick is arrange the document. We'll come to that. It's a full package. When we both do the session, it's a full package. We'll come to that. I just do the documentation. Then after the documentation, I just we could have done that in a workshop. I have files, but so there are various documents. I shuffle it. 15-20 minutes. Just I'll shuffle it and give it to you. What is your duty? Your duty is to arrange those documents in a chronological manner. Then what will you do? That on dated such and such, this has happened. Next, that on such and such, this has happened. On such and such, this has happened. By writing this, you will have a fair idea about the entire fact. Okay, then you ask the client what you want. What he wants, put it there. Correct. Now then you ask the client, what are your grounds? Then you research and put your grounds. It becomes very easy. Right. And one more thing, I'll stop by saying this. My dear friends, please do not think writing big words, writing what you call, fancy words, bombastic words, and whatever, words doesn't make a good draft. Simple, short language helps in preparing a good draft. Keep it as a golden, emboldened, underlined, italic, whatever you want, inverted comma, whatever you put it. Keep it in mind. Whatever you write, you think that if you write, somebody writes it, not a problem. It's good.
No, but it's not a Shakespeare drama. It's not writing a Shakespeare drama. And for that matter, Shakespeare only had 1600 words in his vocabulary. Do you know that? He did not. There are like 1 lakh or more than that words, but Shakespeare in his entire series has only used 1600 words, not more than that. So if he doesn't use, who are we?
Shakespeare also said brevity is the soul of wit.
Yes, you don't use
What?
Brevity is the soul of wit.
Okay.
brevity. And
Brief. Acha,
yes.
brevity is the soul of wit.
Wit.
Okay, thank you. I didn't know that. Okay. So that's why you have to be very. One more thing. One of our senior has told, very senior, he has told me that who is reading the draft? Tell me who will read the draft? The judge. Then opposite party. Then
The public.
sometimes it becomes you get a certified copy, it becomes a public. So once you write it and file it, you never know who is going to read it. Okay. So what do you want? Suppose I write something and give it to you. Suppose you write something, give it to me. What do you expect? You expect that the exact feeling is conveyed. Okay. Not that big words and he has to sit with a dictionary. Right. First point. Second point, very important. You don't know somebody is reading in what state of mind he is. If he is, thoroughly exhausted and you write some big words and he doesn't have time to go through the dictionary, you will just simply throw it out. 2. Number 3. Everybody is not well acquainted with, your vocabulary. The words I use frequently is different from what sir uses. Different from you. So that word might not strike, that might create uncomfortable or discomfort for the person who reads it. So it's better, be safe, be simple, so you have a better draft. Okay? So we'll go to the court procedure. Very brief, half an hour, you will complete it. Then some questions. Okay? So that you will not get exhausted. Or we'll stop. So we'll have a break here. Is that clear? Please clap for yourself.
The entrance I've seen, even if you don't prepare for it, you may get it.
No, absolutely. I agree with this point that you made. The lawyers sometimes take disadvantage of the lack of legal knowledge of the journalist, and they misreport it. They try to.
There is too much of misreporting.
Yes, yes.
There is many, especially in the public issues, which are going, especially in the trials, we see. It's very effective because an opinion is formed. You know, like certain acquittal happened, which everybody thought they were wrong. And why acquittal happened? Because the way a court will see an acquittal
Yes.
and the way as a common person I will see an acquittal are very different.
Very different.
So why does one go to the court then and might as well people try and happen with
I'll give an example. Let's say in a very high stake matter, a big shot, after staying inside the custody for let's say 1 year, is released on bail. And there are certain observation in the bail order that for this thing he has been released on bail. Now, this is being reported by the media, as stated by the conducting counsel, that he has been set free. The language is, he is set free. And the question was put is, जज से कौन निर्दोष? वकील तो कहिबो कि हाँ से निर्दोष. But while giving a bite or addressing the media after the bail order, saying that se nirdosh gives a different. There the journalist should be aware about the legal. So this is a bail order. Prima facie, his custody was not required, or he staying inside the custody is not so important for the investigation. That's why he was released on bail. That doesn't mean he is set free. He is completely acquitted. So many cases you see, in few of my, I had an opportunity of dealing with CBI and high stake matter. There I have never given any statement. Few other persons, those who were in the close proximity, said that he is set free. And the client also understood. That means I have got the acquittal. One of the Supreme Court judges has said, he had told that what is the impact if you don't understand the line. One of the Supreme Court judges, he said in a public forum also that how people believe media to what extent. He is a teetotaler, he never drinks. Way back when he was not a judge, he was holding a glass in a party. He even don't know what was there inside the glass, might be water or juice, whatever. That photo somehow other came when he was elevated to Supreme Court, as a judge of Supreme Court. And the photo was published, that justice so and so, and he has said it in a function. His mother calls, mother or family member. तूने पीना शुरू कर दिया? Okay. No, वही मीडिया वाले क्या झूठ बोल रहे हैं? So that's a norm that media वाले सच बोलते हैं. But it is our duty to, and there is also many of the journalists now, they send us articles की सर टिके देखी दो. এটা ঠিক লেখা হয়েছে না. Then they call it set free, निर्दोष रे खलास हवा, bail रे खलास हवा. It's a different thing. So this confusion is there.
बहुत famous example जो आपका जो farmers issue है.
Yes.
Farmers issue बहुत बड़ा है. It is Supreme Court कौन महिला और कौन reporting मिला. It's a diametrically opposite thing. What Supreme Court said, कि when strike will continue. Say there is no one can ask somebody to not to strike, but put a commission बसाएगी, इंटर लोगों को from the elected field आएगी, put a inquiry commission करके अगर देखा हो कि whether MSP का सेवन जहाँ पहुँच is it valid or not, or whatever international conventions score it चुका अनुसार the subsidy issue will be played and how it should be done. See बुझले कौन कि they have completely supported the
Cause.
And a जो impression rate that continued and it increased in staggering proportion. Quite issue the strike became a big issue because everybody carried an impression the Supreme Court is supporting.
ସେଇଥିପାଇଁ ଆମେ କହୁନା lawyers duty is not just to conduct cases or address to the cause of the client. It is to create awareness.
finally it was during the time of Justice Govt. Finally, he reiterated again after that. You remember that the Republic Day mayhem which happened at the Red Fort. After that, specifically there was a statement made कि अगर support की oppose की करना है, we are only dealing with the technical aspect of the issue. Before giving any judgment, there has to be a committee which will decide whether their demands vis-a-vis the government's contentions are true or not. But in the meantime, to the extent that you are rampaging the airport, because of this somersault reporting, and across the basic problem would have to media. They are basically relying on the mainstream media. Ground level, suppose in the Behera or UP or a farmer is actually reading or seeing the video, it's a completely different thing than what was actually happening in Delhi in a press conference. So, media definitely has a role, sir, but then those who are reporting also should be very careful, because inadvertently, with no cause of doing any harm, much harm is created.
True.
Financially, even fatal incidents have also happened because of this. Somebody not doing anything will just commit a suicide.
Independent journalism anyways is gone. Yeah. And over that, if we misreport most of the things.
And very well-known people are, well-known media is also misreported. This is some call like, bail is set free. Agreed party, just think of the mental strain that point of time.
You'll lose faith in judiciary altogether.
से बुझीबे जे मते तो फ्री कर देले मैं ट्रायल ले जीबी कोन
से तो करे वाला सर जी
या अग्री
प्रेशर इज ऑन अस
एते टेंशन नहीं जो ब्लड प्रेशर ले जो मैंने कॉल कर दी जो मोने
नोबडी विल कम
स्टार्ट करेगा
लेट्स स्टार्ट
यस ओह मोटाटी लगे दिए पण એટલે ता काम करछु मो काम करछु अच्छा ये भी पड़े हुए थे मजे नहीं पता है लाइव एमटी लाइव वाला था
जल्दी से
ओके सो आगु निद्र लागुची
we'll make sure that nothing serious will be discussed.
Yes. এটা লেভে দিলে চলবে তো Sandeep bhai,
someone please just turn on the camera this side a bit. That.
ମୁଁ ସେପଟେ ଯିବି ପୁଣି
ଏପଟୁ ଆରପଟୁ
ନା ସେପଟେ ମୁଁ ସେପଟେ ଯିବି
okay
ସେପଟେ
no
okay
you have to is it coming okay
white ଅଛି ଜଣା ପଡୁଛି okay so we discussed about the drafting and then pleadings and conveyancing and
horizontally
whatever you feel like आपको जैसे अच्छा लगे horizontally रख लो हाँ right now forget everything now we'll understand as a whole in a legal profession what are the steps, what are the, as this is a value added program, you have to understand advocacy. So as an advocate, as I said, you have set your radar, you want to become an advocate. Advocate doesn't mean, I mean advocate who practices, who is in advisory capacity, who is a partner in the law firm, who is a judicial officer, who is a law teacher, whosoever. You need to understand the steps in the profession. In what process we go through. Then only you can say that this is a area where I can excel. Okay. So we start with, see, if there would not have been clients, the profession will not start. As if I said discussed now, a criminal procedure starts rolling from filing an FIR. As we discussed that we always interact with human beings. We address the issues of human being. society. Okay. So first interaction as a lawyer starts with the client. So there is all of you must be knowing that there is a concept called interaction with the client or counseling the client. Is that clear? You all know, na? Counseling the clients. Okay. So it starts with that. So if you write it, client counseling, I say it to whenever students come to my office, I say it, you know it, what is the process? Then you will know where I am standing. Okay. Then suppose, what's your name? Niranjan. What is your name? Asutosh. Now Asutosh comes to Niranjan as a client. Okay. You have some problem. You discuss with him. So Niranjan as an advocate will counsel, will give some advice. That part is over. Then you both decide to file a case. Okay. Then what will you do? What is the next step? Yes. Discussion हो गया फिर? No, first, then he will collect the document. That is called documentation. He will collect the documents. Okay. Now, after the documents are received, then what will happen? No.
What relief will you want?
Facts, okay. Facts is known here. Documentation हो गया. Then you have to make it in an orderly, so in a date chart. Then you do some research. Then you have to do the research. That whatever I am going to do, Niranjan is going to perform the job of an advocate for Asutosh. Then you have to do the research, right? After the research, you prepare the draft. Then draft is over. Then हो गया, draft ready हो गया. फिर क्या होगा? You will have to file the case. Where? In the nearest hospital. Where? Court. Let's say what's your name, madam? Yes. Javina. She is the judge. And you will file before? Judge. So you directly go to madam, please receive the file. You will do that? No? So where you will file? We just discussed. You will file in the office. Right? You file it, then it is called filing. F-I-L-E. Okay, filing. After the filing, you file it. Then what will happen? Who will give you the date? The registry will scrutinize your file. Suppose we were together in an outstation court. There is a public interest involved, and you file a criminal case against the collector, or a civil suit, or a defamation suit. What will happen? Your prayer is not coming within the powers and jurisdiction of that court. One. Or your cause of action, kahan gaye wo? He is not there. Who is talking about cause of action? Your cause of action arises in Bhubaneswar, and you go and file a case in Koraput. Will it be admitted? Will it be received at all? No. So the section will do the scrutiny. We call it SR. Right. After that, then you come. They will give you a date. What date means? No lawyers. Sorry? Date for what? Hearing, trial, okay. Appeal? Or anything else?
Date of listing.
Date of listing, okay. Then? Office note. That's why I said मैं आपको बार-बार बोला रुक जाओ. You are on the point. Yes. Last two. This side, that side. Madam. Appearance. Who will appear? Yes. I sorry forgot your name. Pragyans. Okay.
Whether that will be on that day.
Yes. So that the date will be given for admission. What is admission?
Whether this case is fit to be
Correct. Whether some rights have been violated or you have, if you pass this scrutiny, then date is given for admission. Then what will happen? Let's say A files a case against B. Okay. So A's case is to be admitted. Your advocate will say that these are the provisions law which has been violated. Okay. Yes. So what will after the admission? What will happen?
either the court will admit it or it will reject it.
Reject. No. And let it be that. Summon or notice will be issued to other side because other side doesn't know it. Okay. There is the principle. Why notice is to be issued? Fair trial. What is the principle? Why the other party is to be heard? Wonderful. Who said it? Okay. Then notice. Okay. Then other side will appear. Appearance. All right. Then if he doesn't appear, then there is something else. We'll discuss. Appearance and non-appearance. And after the appearance, he will file his response, written statement, counter, rejoinder, whatever. Then next is hearing or argument. Right. Then after that, I'm just.
Sir, can you switch it off this mic?
This one. Okay. So after the hearing, the final judgment. Okay. Now the judgment, you again have to go back to the client. Okay, sir, you have given me the case. The entire exercise has been done. This is the, this is the outcome. Okay. Now the client, Niranjan and Asutosh. Now Asutosh will say, sir, मैंने तो ये नहीं बोला था, तो गलत हो गया. If he is satisfied, very good, give him good fees. Suppose he is not satisfied, what will happen?
Appeal.
Either you go for appeal. अब क्या amend करोगे? Review or revision? Then that is again another chapter. If there is I'll just touch that if there is appeal provision, you go for appeal. There is, you want to file review. Where you file review? Generally, the same court. Okay. When you file review, what are the grounds? Yes. Who said? Yes. Sorry? New fact will review about. Yes, wait. Wonderful, excellent. When there is any, on the face of the record, there is any error. Right? What's your name? Mukesh. So, you file review, or then if there is no appeal provision and you don't want to file review, then revision. Correct? So, you go back to the client. If client is satisfied, not satisfied, appeal, review, revision. Okay. So, this is the cycle. Is that clear? Anything left? If you understand, our entire procedure, our entire profession runs with this. So this part from, no, I cannot use any other. Yes.
About the judgment spelling.
Spelling?
Sir, a lot of times I've seen some book, it is J-U-D.
Let's ask an English professor.
But a lot of times.
Both are correct. Both are correct. One is American and one is British.
Said, well, let's ask a English professor. He will be better telling us.
True.
See, I had an opportunity of meeting a professor of economics.
Okay.
Abhishek is an English professor.
He is PhD in English, so he should be able to.
Sir, माफ कर दो, गलती हो गया कुछ.
Any dictionary you can consult.
हाँ, अभिषेक सर भाई, अगर कुछ गलती हो गया करेक्शन कर लेना सर. No. I had an opportunity of meeting an excellent professor of economics. Okay. He actually triggered the idea of. He always says, when very small mistakes or doubt remains in a lighter note. Okay. Suppose while teaching economics, some calculation, some small arithmetic doubt comes from the students at PG level. They say, go and ask your school teacher. Go and shoot your. It's a very funny manner. Okay. But he explains it. Professor Prasanna Panda is an excellent professor of economics. I had an opportunity of meeting him several times. So he always says that, okay, भाई हम लोग law पढ़ने देते हैं English वालों को English पढ़ाने बोल देंगे. In a lighter note.
Oh yes sir, no, because I asked this.
You look very serious. That's why I said.
No. Sir, because in normal dictionary we get this, but in legal dictionary I got the E was missing.
अच्छा.
So, in a written note of an advocate, I saw the E was present. So I just
Very
got
confusing.
confused that whether E will be used.
Very confusing. But
My like sir, is like English, the written is in color.
LOU or LOR?
But a legal is different.
SEJD. Okay, so let's come back. Abhishek ji will be taking a class on this.
Sir is correct. In American E not used, in UK E.
Okay, so these are the steps. Now, here client counseling, documentation, research, drafting is a part of your chamber. You do it in your chamber, right? Filing, it's a court's office work. From here till here, it is court work. Okay, then again you come back to the. So while you are discussing or trying to understand the legal research, drafting and advocacy, now I'm the last word, advocacy, then you have to understand each point. Okay, for an advocate, which is the most important step? Let's take quick. Here, one, counseling, very good. Next. बोलो कोई भी. Research, okay, best. Next. Drafting, wonderful. Next. Naam yaad nahi, I could have taken the names. Yes. Filing. Last, madam. Those who are not looking at me, I can ask them. Yes. What was the question? Okay, no problem. Yes. For an advocate, which is very important. Yes. Argument, very good. Appearance. Vakalatnama, very good. Smart. Yes, madam. I'm asking you. I said those who are not looking at, I'll ask. Yes.
Sir, then if the judgment is not been acknowledged by the...
Just tell me which statement. Which state?
Sir, then again from client counseling.
Client counsel, okay. Hearing. Kadam, I would say each step is very important. You leave one step, you are not ready for the profession. Each step, client counseling, drafting, research, filing, then scrutinization, then hearing, then judgments, whatever. Each step you need to learn. Each step. Then only the purpose of this value added course will be fulfilled. You cannot just say that, sir, मेरे को argument बढ़िया आता है. If you say so, then we'll come to our next, that management of legal profession. Okay. So now I leave it to sir for, this is what the cycle, this is about the chamber part. Now the court proceeding, that you have one of your chapter, he will talk about the court proceeding, how the court proceeds, then where from the hearing starts and how it goes, he will say. Then if time permits, then we'll conclude. Okay.
Sir, I have a question. Sir, law of limitation, maximum time I have seen though it is specified in the statute, but still lot of times the actual running doesn't go by the limitation part. Somewhere it is written that within 30 days, within 50 days, it leaves it is left on the discretion of the judge. So after 70 days or 80 days, inordinate delay if the cause is there. But still, the judge gives the liberty to file it. So what's the exact role of limitation? Maximum times if law of limitation is left on the discretion of the judge.
Would you like to answer? See, the limitation period is never extended. The point and the end, the point of starting and the point of end, that period changes. I mean, how we count, that can change. But we cannot say that we can extend the limitation period up to a certain extent. Whether the limitation period will begin to run, whether that will stop at a particular point of time, that can be decided by the court by allowing that petition condonation of delay. So by virtue of that only we are condoning any delay that is arising, and we are allowing the period of limitation to run in a particular way. But we can't say that we will extend the period of limitation as such.
For example, in a civil suit, if some defendant dies or the plaintiff dies, the next legal heir will be the party to the case.
Yes.
Now, he will not be, though he is automatically the next party, but he has to indicate the court only.
Yes.
Now, there is a specific period for that.
Yes.
But a lot of times I have seen that even after 5 years, even after 2 years, so the time variation varies. But that condonation of delay, that maximum times it is allowed. I have very rarely seen that it is being denied.
True.
The catch is, if you are giving good reason for your delay and you are satisfying the court that your delay is not deliberate, intentional, then it is solely dependent upon the judge to his personal satisfaction, backed by reasons to be recorded. Are you getting my words? You have given good reasons for the delay, and you prove that the delay is not intentional or deliberate, and you put it on record before the judge. Judge feels that you are right, and up to his satisfaction, he can give reasons for condoning the delay. Then delay can be condoned.
And the reason why it is done liberally is that, again, it will, if we don't allow, it will give rise to multiplicity of proceedings anyway. Because anyway, he is going to challenge the same before the higher court, or if not, he can bring out a fresh cause of action. So most of the times, court take a lenient view. Whenever a condonation of delay petition is filed, as sir said, there must be a just cause, and that delay must not be is a deliberate delay or intentional delay. Then court has to construe it liberally. Okay, coming to the, I think sir has very well said what are the steps that are to be done for you to become an advocate. But I would say that all of this applies to you generally, not only if you want to become an advocate only, if you want to be a teacher, because I believe some of you might be interested in academics, some of you are PhD and then want to do NET and all of that. Are you interested? Nobody is? Or all are looking to go for profession only? You have to tell me then. Judiciary, how many of you are interested? Okay. So the lion's share goes to judiciary once again. A profession? Is 2. Okay. That's again the normal standard. And teaching? Nobody teaching you. Okay, good. And any other field like corporates and other thing, if any other profession, UPSC.
He's gone.
Oh, he's gone. You are interested in UPSC?
No,
Corporates. You are interested in corporates. What is it? Law officer. Okay. Oh, he's also gone. He was interested in a corporate firm. So all of this applies to you generally. Why do I say so? Maybe if you're an advocate, some of the parts will be missing, like the client counseling part will be missing, the documents part. But then nevertheless, for a judge also, the document, the research part is the most crucial here. If I want to stress on something which has to be very particularly looked into, that is research. Research, legal research, ma'am was asking a question, legal research, what is the importance of it? Because imagine a situation, you, sir gave an example, if I am from Bhubaneswar, I can't go to Bodh and file a case. Forget that. There will be territorial jurisdiction issue as well. There will be pecuniary jurisdiction issue as well. There will be subject matter issue as well. For that matter, now these commercial courts are coming up. So what suit was originally scheduled to be filed in a civil court, civil judge, before a civil judge, now is being filed before a commercial court. So if you approach the civil court, that will be wrong. That will not be entertained because there is a specific commercial court for that to happen. And how will you know? By doing research. And research does not only mean that you will study or you will prepare that case. You should be, as I always say, that you should be always in a position to add to your knowledge and delete from your knowledge. That is very important. Because if you have learned something, it's very important to unlearn that if it is a wrong concept. Because most of the times, still then I find that while we reading CPC, I must have understood in a way that is not actually the correct way. And now I have to unlearn that process. So you should be in a position to always unlearn. So research part, you have to take care of that very carefully, and then only all of the drafting, you already know, sir said how the drafting is to be done. And from the court, once the court comes into picture, one important element that you have to play, whatever stakeholder you might be an advocate, you might be a judge, you might be any other officer of the court, you have to be a good manager. You have to manage the court properly. So client also you have to manage, case also you have to manage, and then you have to, in a court, you have to be a good manager. For a judge, definitely I think if an MBA becomes a judge, he can be 1,000 times better a judge than what a normal person can, because they know how to manage the court. And court is what? Court is, there will be a person, there will be another person, there is a dispute between them, there are two advocates who are representing them, there are certain officers of the court, there are police, and there is prosecution, and we are just managing them, and it is a machine to which some input is given, and we are just the button. As a judge, you are just the button which is making sure that input is taken out as output. As an advocate also, that is your job, is to be a good manager. That means you have to conduct yourself properly. That means you have to, just because he is a peskar thibe, apanଙ୍କର court रे peskar thibe, तार role बहुत important. आपण खाली करि परन जे से staff, mere staff, what will he do? तार role court रे equally important, because most of the times, though court should fix the date, most of the times he will fix the date. आपण जदि पेशकर सहित ठीक रे नथिबो, आपनकर रेट एते लंबा पड़थिबो जे आपण चाहिले भी रिलीफ दे परिबेनी, कल सकाळे क्लाइंट ही आसीबे. तेणु मैनेजमेंट इज वेरी इंपोर्टेंट. कोर्ट रूम मैनेजमेंट बिकम्स वेरी इंपोर्टेंट. ऑल दिस स्टेप्स यू नो, फाइलिंग रु आपण जदि जजमेंट परंत जिबार अछि, दैट विल सेतरे त किछि हमकु माने मु भाबुनी जे किछि एलाबोरेट करिया कथा, एक्सेप्ट दिस वन थिंग दैट यू हैव टू मैनेज द कोर्ट रूम प्रॉपर्ली. कोडा okay, so if we want, okay, so out के भी सर को जन सेटा कहि दवा जे सुप्रीम कोर्ट, हाई कोर्ट और लोअर कोर्ट रे स्पेसिफिकली कोर्ट रूम रे कोन हो, सेटा भी हम डिस्कस करदवा. जदि फर्स्ट हम देखि दवा सुप्रीम कोर्ट रे कोन हो, आज हम देखिले कि ए हम फाइल करथिले, तो मोर ऑफन देन नॉट सुप्रीम कोर्ट तो फैक्ट फाइंडिंग कोर्ट नो, सो एविडेंस पार्ट सेटी नहीं, दैट एविडेंस पार्ट इज नॉट देयर. So what will be done? You will be filing, there will be a counter. First it will be fixed for admission. Once it is admitted, then it will be fixed for appearance. If the party appears well and good, if it does not appear, even though it has been serviced well, then there will be an ex parte order. What is an ex parte order? We all know that an order is passed in the absence of the other party, because the party was given a notice but he still did not appear. So there will be more often than not ex parte order if the party does not appear, and if he appears, then he will file a counter. And if he files a counter, you can file a rejoinder. And rejoinder means, that means because he added something, now you want to add something to your affidavit or your petition. So you will find a rejoinder. And after you do all of that, there will be a hearing, and after the hearing is done, if any arguments will be made or documents are to be supplied, all of that will be done, and then there will be an order, which if it is favorable to your client, then you will go with it, otherwise you will go to the higher forum. There are many higher forums that you can approach step by step. You will go and until you get a satisfactory decree for your client, you have to do that. Now coming to the, yes.
When someone goes from lower court to higher court, now the higher court only agenda is to look after whether the judgment has erred in some, they have left some, the law fact is only seen. In the Supreme Court, does the lower court order also comes to that play? Means the high court, they will scrutinize the high court order or?
No. They will scrutinize all the orders. All the orders. So they will hold a view necessarily that the magistrate held this view. It was challenged in the district court and the district judge there held this view. It was challenged in the high court and the high court probably overturned it. And now what we think of it. So they will discuss all the orders. It's not necessarily that they will discuss only the impugned order that is there in the question. Why? Because more often than not, you can't reach to a particular conclusion without in fact going to the trial court. Trial court you have to see. Because again, you can't discuss facts. You have to only be limited to law. So for facts, you have to refer to the evidence that has been already taken in the trial court. That must be a magistrate court who has taken all the evidence. So without discussing it, you can't reach to that. So Supreme Court will discuss all of that. Okay. So yes, Supreme Court is over. Now High Court also in similar light things will be done. There will be filing, and then there will be a filing, and there will be hearing and admission. Once it is admitted, there will be posted for appearance. If he doesn't appear, then there will be non-appearance, and by virtue of that an ex parte order will be passed. If he appears, well and good, he will be allowed to file a counter. If he files a counter, you can file a rejoinder. If you file a rejoinder, there will be hearing and there will be order. In lower court, there will be a step further. What is that step? That there will be evidence. So that means there will be examination, cross-examination and re-examination and further cross-examination. So all of these will be there. So these will be done in trial court. That say step filing here, it will be fixed for admission. So someone mentioned office note. Office note becomes very important here because the head clerk, he will make an office note. That whether office note is what? Office note is saying the things that need to be done for a suit to be admitted. For a suit to be admitted. That means a suit cannot be admitted if it is improperly stamped. So the stamp paper will you admit the suit? You will not admit the suit. If it is undervalued, will you admit the suit? You will not admit the suit. So office note is more often than the mirror of the plaint and the suit that you have filed. So in one page, he will substantiate that these are the requirements. He will not dwell into the fact that whether a relief will be granted or not. He will not look into that. That office note is to make sure that whether it will be admitted or not. And once it is admitted, then it will be again fixed for appearance and notice will be issued. So if someone is served properly and he doesn't appear, then ex parte. If he appears, then he will be appearing along with the written statement. If it is a civil suit, then he will be filing a written statement. If it is an intermediate application, then he will file the written objection thereto. And if it is a criminal case, then he will appear and he will be ready to contest the case. And once he contests the case, then all the evidence will be taken. All the examination of the witness will be done. Once the witnesses are examined, then only arguments will be done. Before that, accused statement, if it is a criminal case, accused statement will be done. If it is a civil case, then it will be fixed for evidence from the other side. Both the things are taken care of, evidence is taken. Now it will be fixed for argument, then there will be judgment. And if you get a favorable judgment, you stick with it. Otherwise, you appeal it with the higher forum. So that is in fact, in short, all the things that will be done in a court. Okay?
You are saying I was putting it in diagram.
Good.
Then coordination. So that we coordinate well.
Could you follow this diagram? I can make it more pictorial, more artistic. Unfortunately, this is not supporting, only this guy is supporting. So here, as sir said, you have the plain A's case written in the proper draft format, filed in the office, give you a date, admitted, notice to the other side, appears, and he files his objection. After the objection, the court decides issue. What are the questions you are supposed to address before the court? Right? I think as a judicial officer, as a judge, you must have framed so many issues and addressed, delivered so many judgments. At least per month, 30 judgments.
Per month you have to at least deliver 30.
At least 30 judgments. Right?
That's the yardstick, but that's the minimum. So if you
go above that.
if you do the 30 judgment, that means you are a poor judge. So in order to become a good judge, you have to at least deliver 40, 50, 60 judgments.
Okay.
Otherwise,
so you have to frame the issue.
Per day is written that.
Per day.
Yes, yes. I think she
Yes.
has been to court.
Or she must be having a judicial background, maybe, I don't know.
No, have you been to the court? Yes, another board like this.
Okay.
Yes.
All right. So now, whatever pleadings you have given, could you follow? What I say? जो भी डॉक्यूमेंट this professor we are privileged to have our friend as professor of the department. Yes. So whatever pleadings you have submitted, you need to prove it by an evidence. Right. So you give your evidence. Evidence, how you give? You give oral evidence, documentary evidence. Another in criminal side, we just I think missed that there is something called material object. Right. What is the material object? A kills B by way of a knife and throws it somewhere, and that is seized. That is called material object. Okay. And oral evidence is basically given in three stages: examination, cross-examination, re-examination. So now, before the court, plaintiff's case is there, first party's case, second case WS is there, evidence of both sides is there. Right? Now it is ready for hearing. Correct? So after that, judgment. I think this is what is
Yes.
procedure. Right? And then judgment comes. Judgment. Then if you are happy with it, otherwise go for appeal revision and review. Is that clear? This is a court proceeding you could understand. Now whenever you go to the court, now you will see that in which stage. I have said date. तारीख पे तारीख यहाँ पे लिखा गया है. So what are these tarikhs? What are these dates? In each date there is a formal order. Like Rajat sir writes, he doesn't put the signature. Right?
I don't. I used to.
Oh, okay. Okay. Sorry. Sir, English sir, full tense toilet. Okay, he used to put signature. In all dates, whatever is written in the formal order sheet is called order, and this is final judgment. Whatever the formal expression of the proceedings are called orders, right? And the judgment. This is the court proceeding. Whenever you go to the madam, they say something. Okay. Whenever you go to the court or you come across any record, just keep it in mind. You are seeing the record in which stage? Either it is admission stage, or appearance, or filing the reply, or framing of issue, or evidence, or hearing. Which stage? Then only you can get it. Like why I did this? Because recently madam said that we face difficulty in assessing and knowing the exact position of the case. Because we don't know the procedure. We are here, issues are framed, but we don't know. Issues are framed, some of us might understand the issues are framed, it has been decided. Right? So this is the procedure. Right? I think this the major part is over. If
Adam login. On करो. On ही नहीं.
Okay. Now is it clear? Okay. How come we sir do? Our 10 minutes अच्छे होते हैं तो और ये बस खाली touch कर दीजिए touch कर दो first of all.
Do you know this concept of 10,000 hour rule? Anyone has read about this? It's an important, I mean interesting, not important, interesting concept. 10,000 hour rule. Gladwell करो वो concept थिला.
Very important.
Very important for anyone to excel in their profession or आपण जदि गोटे किछि job करछन तो that is fine because you will again do a routine job. You can be a good judge, bad judge, nevertheless you will be a judge and you will be getting paid for it. But since we are in profession, or if you want to be a teacher, or if you want to be a musician, if you want to be a cook, so for that you have to learn this skill and you have to master this skill. Then only you will be able to excel in it. And for that to happen, Gladwell gave this concept called 10,000 hour rule, golden rule of 10,000 hours. That means to excel in a field, you have to give 10,000 hours of your hard work in it. Excel in any field. And 10,000 hours, if I largely put it, in a week, how many hours can we work a day? 6-7 hours? So 7 hours, presuming it's a 6 days a week. So it will be 7 hours. 7 hours jodi bi ame daba. Tale 7 hours jodi daba regularly 42 hours hala. So that means it will roughly come around 4 years. Okay, so you, in order to master the profession, you roughly need 7 hours of hard work in the same for a period of 4 years. Without that, according to Gladwell, not according to me, you can still beat him, but he says that you can't. Because he says that if someone has put in 10,000 hours of work, he'll be definitely better than someone who hasn't. Of course, the general rule is also, the more you work, obviously you'll be better, but you'll be mastered if once you do that. So try this 10,000 hour rule. You can maybe increase it to 12 hours a day in order to reach there quickly. Some people can do it 16 hours a day in order to reach it quickly. So suppose you are playing flute. So that example particularly he gave it with the flute only. So somebody in a university I think, people were, or violin probably. So in order to be a master of violin, they played for more than 10,000 hours and then they mastered the same. Then you learn on the notes, all the nitty-gritties that are there, anything that is there, at least you know the concept, at least know you might not, and more often than not, we don't have to remember the law. We just want to know, we just are interested to know where the law is. Our job is to know where the law is. What the law is, that is there in the Behera. Even AIB does not want you to remember the law. They say you carry the Behera, if you know the law, you write it. So you don't have to really remember it. Just know the concepts, just understand the concepts. Kichi semti concept no tha jota ko alien lagu. Law or a concept, if it is alien to me, then I'm still a student of law. No, I'm still saying कि नानी पालके वाला भी कहते जे he is a forever student of law. आमे भी समझते forever student of law काहे कि because new laws will keep on coming. New laws will keep on coming. एबे हमें पढ़िथिले कि थोड़े हमें cryptocurrency ऊपर जो बिल आसुची. Did we even think कि गोटे एमती गोटे आसीबो गोटे currency which will not be having any physical form, it will still be a valid currency and it will be in fact the most powerful currency. Most powerful currency to the extent that one Bitcoin is 42 lakh rupees. So imagine, did we ever think of a situation like that? And there will be NFTs. Now NFTs are coming, so non-fungible tokens, or they are saying. So there is not physical existence of the same, but they are arts. So yes, so there will be again bills to regulate that. So that also we have to learn. Now criminal law amendment bill is being introduced. So that will be, again you have to learn. So you will be forever student of law, but at least put this 10,000 hour to work, and I'm sure results will follow.
So one thing, after this evidence, this chief examination, re-examination on both parts, after that again you have come to evidence A and B.
No, these are the documents which is available before the judge.
Okay.
I put it in a box. that plaintiff's case, defendant's case, and the evidences. These are the documents available. Okay, so this is not a process. That's why I have not written date. Date means in the court process. This is a document.
And then P and W on the side.
Plaintiff's case, written statement. Plaint and written statement. I mean, Rajat sir was speaking so fast that I had to do the diagram.
Okay, so I think we should throw the mic to you so that you can ask any question that you have. And then, yes, of course, your question will be answered. Other than that, if
Demand and
there is any other questions,
any question
on the class, outside of the class, any doubt that is there in your mind, you may raise the hand and just...
In fact, in many of my sessions, I always, I have done it in some colleges. I say that let's pick the most useless topics that comes to our mind. Let's pick it and I make a list. And out of that list, we start discussing about the most useless or not so important topic, and we started discussing. And ultimately, every time, 3-4 times I have done it. Every time we land at a legal proposition or some social issue. So why I say so? If you do something in an organized manner, you will land in a very positive note or in a productive note, right? So irrespective of you are in a program or in a session, whatever comes, you can ask and we'll wind up. We would take another session if required on economics and management of legal profession. That's very important to learn, especially those who are in PG level.
So not today, later. Yes, question you.
So from the starting you told that when you will tell us some good
Tricks to remember.
tricks to remember, mainly
Okay.
the sessions, I think.
Okay. Acha, ठीक है. Okay.
So I have done my BF in sociology honors. So there we used to we learn the concept and we have learned it in means our professor had told it, and then we just need to remember the meaning of the concept, and then we would write it in our own language. But when I came to law, you have to remember the sections, which section, by what you have to remember it, and then you have to put the case laws in it for mainly the exams. So how to do that? Because I am not quite...
That is quite debatable, I'll tell you. I just now said that you need to know what is the law. Where is the law, you can find out first. And I am a strong believer of not learning the provisions or sections by heart, because it is not required. Whenever given an opportunity, I would suggest that all the examinations for the law students should be conducted inside the library. You sit in the library, we'll give you the propositions, find out from the books, write it in your own words. I strongly believe that in that system. In fact, whenever I got opportunities to take sessions with the syllabus and conduct examination, I have done it. I say that your examination is for, let's say, 1 hour. I'm giving you 1 hour, 15 minutes. Okay. And I'm closing the door. Whatever you want to do inside, not a problem. 1 hour, 15 minutes, 1 second I will not give you. This is the question. Prepare. You want to Google, you want to go for books, not a problem. Prepare it and write it. Then what will happen? Your interpretation skill, your understanding will be tested. Right? Application to this. And in that case, the teachers have to do more work, because the question, I cannot put simple question, murder is defined under which provision? You can easily get it. Then I'll give a situation where you have to define that whether this situation amounts to murder or not. Okay. So that's it. For preparing that situation, I have to do the homework. So it is always, both the sides has to work hard. So if that is the case, I think time is going to change, where in our universities also, we will have, I think some of the universities have started it, but we seriously suggest open book examination. You logically, you interpret, yes, right. So you don't require, first. Second, if you can remember the provisions of law, there is no harm. It is not something which is impossible. It is not something very impossible. So if you can remember, there is no harm. By just saying that, sir, it is difficult, I am not remembering, I would say that it's an excuse. Number 2. Number 3, in any subject you pick up, any statute you pick up, there are certain important provisions of law in that particular statute you have to remember. And it gets memorized automatically. Because if you see, there are 2 parts. One is a substantial part of this provision, another is procedural, another is powers and function. Right, 3 aspects. So basically we have to remember the substantial provisions of law. Then when you see the procedure, then it becomes very easy because that is the path. So you don't have to remember the provisions. It's where it starts, it goes on. Okay. Then it remains powers and function of the forums. Right. I mean, Durga can explain. I have seen his interview. He explains it well. Right. Am I wrong? There are 3 aspects. No. Anything else is there?
No.
So one is substantial provision. Next is the procedure. Third is powers and functions of the respective authorities or the forums. Not very difficult to remember.
Sir, how important are case laws to be put in, like the OJ's exams? How important are
Let's hear it from Durga sir.
patients are also.
Let's hear it from recent stated. Anyone else other than Durga who are qualified? Okay. Now, yes.
So what is the question?
How important are the case laws to be cited in the answers in the
See, if the question demands that, if the question is like that case law is required, suppose it is a current legal concept, suppose it is about the current legal developments, then the case law is required. If it is asking you to put reading the case laws, if suppose a provision is interpreted by certain citations, then it is required. But if it is barely asking you to put down the provisions, then there is no necessity to put case laws.
If it's like asking for only the provisional part of it,
Yes.
then we have to write only
In
the
procedural
section.
laws, you need case laws. In IBC, you need case laws. But there are certain things where you will not get time to put those case laws in the exam. So if it is required, if it is really necessary, then you put case laws.
I have a question. So what is the value of a judgment of another state? For example, the High Court case for the lower judiciary of Odisha, for example, Odisha. The lower side says, Delhi. Is the lower court bound by that decision?
No, not binding at all. What is that concept called?
Persuasive.
Persuasive, Latin word I'm forgetting. But it has only persuasive value, but I'm not remembering the Latin term. Pardon? Stare decisis. No, stare decisis probably, that's the concept, yes. So stare decisis, it has only persuasive value. That means if I want the principle, if the judge likes the principle, if the court is concurring to the principle, yes, in fact the statute has been interpreted nicely by a Karnataka High Court judgment. Even though it is a Karnataka High Court judgment, I can rely on this. But if the judge does not believe the same, he can still reject it. But own High Court, you can't. Or Supreme Court, you can't. Unless there is another judgment which is overruling the same.
Sir, I have a silly question.
Yes, no questions are silly. No questions are silly for that matter.
Out of syllabus. Sir,
Was there any syllabus for this session?
those
We don't follow. None of us follow syllabus. You give us syllabus, we will go.
judges who are appointed in lower judiciary, but they are not appointed to Supreme Court.
Why is the process of elevation from lower judiciary not so prevalent? That
Advocates are privileged to mainly go to Supreme Court.
that is because of only one thing, that they can't reach that stage of being elevated. Once you enter lower judiciary, you can't reach that stage within your career span. You can't. I mean, it's practically impossible. Even if you suppose crack at the age of 23 or 24, then also It will be very seldom that you can reach at a stage where you will be the Chief Justice of a High Court for a certain period of time. No. At least you will be you can reach the High Court, but I don't think you can reach up to that. If out years maybe we would reach that. But advocates they are in a better position because upon 40 years, 45 years, if you are directly elevated to High Court, that means you have a greater period of like, because 60 hochi kona our lower judiciary career span 62 hochi High Court or 65 hochi Supreme Court. तो 65 पर्यंत तो एज रहा दरकार ना तो एज ही रोनी बोली पहुंच पारना ना पहुंचार किसी प्रॉब्लम नहीं. इनफैक्ट एबे तो कर्नाटक हाईकोर्ट से जो लेडी जज आई एम फॉरगेटिंग द नेम भानुमती जस्टिस भानुमती शी वाज ए मुंसिफ शी वाज ए सिविल जज जूनियर डिवीजन शी वाज अपॉइंटेड एज ए लोअर कोर्ट जुडिशियरी हु रीच्ड सुप्रीम कोर्ट. जस्टिस भानुमती रीच्ड कर्नाटक और केला आई एम फॉरगेटिंग शी रीच्ड सुप्रीम कोर्ट शी रिसेंटली डिसाइड एई गोटे वर्ष तळे सो ताकर सेमती लक थिला जल्दी जल्दी प्रमोशन हे गला केही नथिले ये प्रमोशन हे कि जल्दी हाई कोर्ट जज पहुंच गेले एंड देन ताकर स्पैन पळे आसला आसी गेले हमर सेती ओकेजन करूनी आ कोन दैट इज दिस ओके आई विल आंसर यू ओके आपण कोन.
So before answering that question, I just want to know that what drive you towards that position and then you to be.
Okay. Yes. So yes, that will be the logical way to go about it. That why did I join judiciary? Why did I join judiciary and why did I quit judiciary?
Because quitting needs more guts. How did you get into that position? Still, everyone has that drive.
Yes.
But quitting a certain position, it takes a lot of guts and a lot of energy. It's very traumatic experience, which I have also experienced. That's why
You quit a job?
Yes, sir. I have left job.
Okay. Well, what were you doing?
I was previously working with the Airport Authority of India.
Okay.
But left that. I was subjected to only Bhubaneswar, and I was a finance consultant at Bhubaneswar.
Okay.
Then again I left that job to pursue my livelihood.
Okay. So I'll tell you why did I join judiciary in the first place.
So why and how?
Why and how? Okay. Why and how both. After this, I was in ULC 5 years. I completed. Honestly, I did not want to come to law. I don't say this often, or I don't say outside of my family. Nobody knows probably. I never wanted to come to law. Both my parents are in judiciary, so they kind of forced me into this because it's like nahi doctor हुए तो they were like they were fixated कि law करियो ही करियो. In fact, I did all the things possible on my part so that I will not get into the law because mo entrance exam रे भी I marked it unnecessarily mo mark करजी. CLAT रे देवो कहले और इठी देवो कहले mo unnecessarily mark करली. अच्छा CLAT रे तो हेलिनी because unnecessary mark करथिली. एमाने कोड लेवल रो एंट्रेंस करथिले mo जानि I still got it. एमाने माने with all due respect to the Utkal University and then my career took this turn and जतले आसी गली then obviously I had to be serious about it. It's not like कि आसी गली नहीं आवे तो there is no going back. So law कर देली. Law करला परे सेतले भी इच्छा नथिला okay what is the next thing that I want to do. I was fixated कि UPSC करियो. But UPSC ପାଇଁ I had gone मु जाई कि Delhi रे I was preparing. But there I got dengue थरे हे गला. तापरे I came back पुणी आउथरे जस्ट जाईची पुणी आउथरे चिकनगुनिया हे गला. तो probably the destiny had that set कि मु चिकनगुनिया रिजल्ट नेक्स्ट टाइम आस्तली ये प्रीलिम्स एग्जाम बाहर करी बसतिले ସେମାନେ. Again मु कहूची पर I am माने destiny how it takes you to where it wants you to reach. I am a prime example of that. And law तो ठीक ठाक पढ़ी थिली माने God's grace आ बाबा जेतु सबले he was my prime teacher तो ठीक ठाक रे कांसेप्ट एटलीस्ट बुझिथिली. तो जेतले आसिली एठी घरे बसची चिकनगुनिया रे मते कहले प्रीलिम्स दे म कहले हो दे देली पाई गेली. तापर कहले मेंस आ तो हे गेलानी मेंस भी दे दे मेंस भी दे देली पाई गेली. He knows Durga is my brother. If anyone doesn't know, Durga is my brother. So he knows how I have prepared. I haven't prepared at all for judiciary.
Those who are aspiring, don't prepare like
me. So
prepare like Durga.
Prepare like Durga. He was sincere and all. So सेमती कर करिए. तो देरी पाई गली. But I was never driven. That is the driving force टा रहा दरकार ना. Because I was not enjoying the process. एक तो मते लागिला कि टिके मु लिमिट हे जाउची जहा मु करिया चाहूची से करि पउनी सेटा गोटे करि पलेनी. प्लस क्या टिके पर्सनल प्रॉब्लम रहिला For that I was compelled rather, or ମୁଁ ଇଚ୍ଛା ବି କଲି ନିଜେ ଯେ ନାଇଁ ମୁଁ maybe I will be better suited here.
Please.
Yes.
That's why now as this has come to give it this experience an academic angle, because we are in a program, we have to justify it.
Yes.
Right. That's why everybody has to do the SWOT analysis. What is a SWOT analysis? Strength, weaknesses, opportunities, and threat. I don't say threat, challenges. Everybody has to do their SWOT analysis. You need to know what is your strength, what are your opportunities, what are your weaknesses, what are the opportunities you have and you can create. Now by setting your radar, you can create opportunities. Are you getting my point? By setting your radar, you can create opportunities. Then challenges. There are many examples. Those who have done the jobs, they know that how SWOT analysis is important, right? So that SWOT analysis has to be done from the very beginning when you are into UG course, right? Second is very important is you need to know the worth, then you need to work in that direction only. Worth means if I am good at this, weakness as strength. My strength is I can teach better, I can speak better, but I cannot sit for a long time. So if I am put to judiciary, I have to sit from morning to 4 o'clock. Then what will happen? One, if I can speak better, I can be a good lecturer, good teacher, right? That exercise you have to do. That is why we were developing a concept for management of profession. You have to apply the management principle to your personal life to understand the profession. Then only you can excel. Are you getting my point? First. Second, dream that 10 years down the line, 5 years down the line, where you want to see yourself. Are you getting my point? And your goal has to be very, we will just complete now with this. Huh? Okay, let them come. We'll complete with this.
Yes.
No, otherwise it will go on. Any other questions? Yes. Then we'll say the last line and complete. Yes.
Matters of juris.
କିନ୍ତୁ ତାର ଆଉଟ୍ ଅଫ୍ ଷ୍ଟେଟ୍ ସେଟା ଟିକେ କମ୍ ଯେମିତି ମୁଁ ଜାଣିବାକୁ ପାଇଛି ଡେଲିରେ 50,000 ସମଥିଙ୍ଗ କରୁଛି। ତ ଯଦି ମୁଁ ଯାଇକି ଡେଲିରେ ରେଜିଷ୍ଟର କରୁଛି ମାନେ ମୋ ଲାଇସେନ୍ସ ପାଇଁ, ଆଉ ଯଦି ଆସିକି ପ୍ରାକ୍ଟିସ୍ କରୁଛି ମାନେ ଯଦି ଏଆଇଟି ସାରିଲା ପରେ ଯଦି ଓଡ଼ିଶାରେ, ତାର କିଛି ଏମିତି କିଛି ଆଉଟ୍ ଅଫ୍ ଷ୍ଟେଟ୍ ମାନେ ଏମିତି ରେଜିଷ୍ଟର କଲେ କିଛି ମୋ ପାଇଁ ପର୍ଟିକୁଲାରଲି ଆଡଭାଣ୍ଟେଜେସ୍ ଅଛି କି?
ନା, ମୁଁ କହିଦେଉଛି। Yes, you're saying something. You're saying something. You are answering. Please, not a problem. No. तांको question है suppose मु दिल्ली रे enrolled करूची, then I am coming back and practicing in Odisha. Is there any problem?
No, sir.
अच्छा, we'll have debate on this. Okay. We'll have a debate, not a problem. But debate has to be backed by some research. Right. Sir, what's your name? Swaraj. Swaraj and Sandeep will be fitted against each other here. But answer is, you have to understand the rudiments. The rudiment is, anybody who is enrolled in any state bar council as an advocate can practice anywhere in the country. There is no bar. Full stop. Now second is, after enrolling yourself as an advocate in any state bar council of the country, you are eligible to practice, but you have to appear for All India Bar Examination to get the certificate of practice. Alright? So, after enrolling, after getting certificate of practice, there is no bar in practicing anywhere in the country. Correct? Now coming to Swaraj's statement, I'll put it otherwise. There is no misconduct if you practice. But if there is any misconduct by you, then your complaint will be adjudicated by the Bar Council of Delhi, not Odisha. Are you getting my point? Suppose I want to file a complaint and you are enrolled in State Bar Council of Delhi, the Bar Council of Delhi will take up your issue, not Odisha. Correct? Fourth, because we need to be very particular. We cannot. That's why I'll come to the last line. Next is, suppose you want to contest for Bar Council election or you have to cast vote for Bar Council election, then it is only in Delhi because your enrollment is in Delhi. Correct? So then if you want to transfer it, of course you can transfer it. You got your answer? Right. And so far as this, when we don't want to comment on this, for this just for your information, so far as this difference in fee structure is concerned, this matter is sub judice.
Yes, sir, I know.
Correct. Any other question? Okay. So that's why I'll just complete. Just we were reaching towards, everybody is talking about achieving a goal. Okay. There are three things. 10 years down the line, where you want to see yourself, just think of it. That will drive, that will help you in deciding the path. First, setting the radar. Second, understanding your worth. मैं कितना पानी में हूँ? Please don't mind. If I am not being able to understand the basic laws and I'm thinking of becoming a jurist, no problem. But I should know my worth, so that I should know my standard, so that I will put accordingly. I'll put efforts. Right? Are you getting my point? So that very good important is accept your standard, accept your acumen. You might be very good in dancing, so you can become a good dancer. Right? If I am not good at playing cricket, there is no harm in accepting that, sir, I cannot play good cricket. If I want to become a good cricketer, I have to put like 10,000 hours rule. I have to put that much of effort. So those who are aspiring to become somebody in the legal profession, do your SWOT analysis, know your worth. हम कितना पानी में है किसी को बताने का जरूरत नहीं है, खुद को बता दो भाई, तो खुद बच जाओगे, फ्रस्ट्रेशन से बच जाओगे. This might sound very rude, but that is the real fact.
It's true. In fact, any of you has watched Game of Thrones, there is this famous saying by Tyrion Lannister: wear your weakness as your armor, then no one can use it to hurt you. तम weakness को तम armor भला पिन दलो जाए. So I am bad in English. So what? No one can use that against you, and you will improve only.
Correct. Correct. ये अगर कर लिया ना भाई, everything becomes easy. You will not feel, because human mind, human life is such, we are afraid of accepting the negativities, accepting the loopholes. Right? Number one. Number two, I'll tell you just 10 years down the line where you want to see yourself. There is a process, complete half-an-hour process. We do this process. Now you all are not in that mindset to do that, but you can do it at your home. When keep the phone aside, just keep quiet, sit, meditate, think 10 साल बाद मेरे घर के सामने क्या बोर्ड लग जाना चाहिए. What assets, what liabilities I should have. What should be my designation? That will give you a proper kick towards your goal. That's why when you say goal, your goal has to be SMART. I derive it as a SMART. S for specific. Specific means it has to be, the more specific you are, you will be more driven. Somebody say, I want to be a good lawyer. No. Good lawyer means what? I want to, argue matters. I want to argue matters in Supreme Court, High Court, Lower Court. I want to do trial. You have to be very specific. I want to join this senior's office. I want to start practicing this year. Very specific. Next, aim, measurable. Measurable. It has to be quantifiable. You cannot say, I should have a lot of money. It makes no sense. Right? Then, A, achievable. Like somebody asked the question, why lower court judicial officers are not being able to go up to Supreme Court? Today somebody joins at the age of 35 or let's say 33 as a judicial magistrate second class, and he dreams to become the Chief Justice of India. I don't mind. Let he reaches. But what effort, whether it is achievable or not, that assessment you have to do. And if it is achievable, you feel, then accordingly your effort has to come. Otherwise, you will become sad, you will become frustrated, right? Then it has to be realistic and time bound. For your each dream, each goal, you have to fix a time. On this, you are doing PG, by next 2 years, your PG has to be over. You want to join academics, next 1 year, 2 years, I have to complete my NET examination, PhD or whatever. So time, it has to be time bound. Without time, again, nobody will lose, you will only lose, we will only lose, right? So ultimately coming down to the last line, knowing the self-worth and knowing the SWOT analysis of a person, that I am best at this. And बचपन से बोला जाता है कि भाई you are bad at maths, so work on maths. I say otherwise. If you are good at English, work English, tomorrow you will become a good professor in English. तो जो अच्छा करते हो उसके ऊपर ज़्यादा फोकस करो, जो नहीं हो रहा है उसको एक्सेप्ट कर लो, मैनेज करके चलो, so that you can excel in that, because you have an interest, you have an acumen to that, because each individual is blessed with certain exceptional qualities that needs to be understood. That is what the actual meaning of adding value. You have some value within yourself, add to that. So who knows what value you have? You only can know it, right? Thank you.
Any other questions? Well, on behalf of entire this Department of Law and the legal fraternity of this university, I would like to propose vote of thanks to the special dignitaries who is present among us. So for that, token of love on behalf of the department.